The Rights and Duties of Spouses. Sayyid Abul Ala Maududi, Nawaudi, Markazi Maktaba Islami Publishers. Human Welfare Trust publication. No Semi-C Human Welfare Trust, Rajidenda, New Delhi. All rights reserved. No part of this publication may be reproduced, stored in a retrieval system, or transmitted in any form or by any means, electronic, mechanical, photocopying, recording, or otherwise, without the prior permission of the copyright owner. Name of the book, The Rights and Duties of Spouses, English version of Urdu, Hukuk uz Zawjain, pages 152. Author, Maulana Sayyid Abul Ala Maududi. Third edition, May 2009, 1,100 price, Rs 55 in Gurar, published by Markazi Maktaba Islami Publishers, D307 Abul Fazl Enclave, Islamia Nagar, Okhla, New Delhi, 11,025, PH 2697, 6 time 52, 2695434, 1, fax 269478858, email mmIpublishers@gmail.com, website www.mmipublishers.net, printed at HS Offset Printers, New Delhi 2. So take what the Apostle assigns to you, and deny yourselves that which he withholds from you. Al-Hashr 7. Contents. 1. Forward. 3. 2. Objectives of the marital law. 8. Preservation of morals and chastity, love and compassion. Marital ties with non-Muslims compatibility. 3. Principles of the law. 14. The first principle, the duties of man, injury and oppression, not being just to wives, rights of the husband, man's powers, counseling, admonition, punishment. 4. The second principle, 24 conditions for divorce, Khula precedents from early history, mandates concerning Khula basic errors, about Khula powers of the court in Khula the Sharia tribunal. 5. Fundamental issues about the Sharia. 39. The first condition for the court independent thinking is essential harm done in India by the absence of Sharia bench, the first step towards reform, need for a modern legal code. 6. Fundamental instructions. 47. 7 corollaries. 52. Apostasy of one of the spouses, discretion of adulthood, obligatory guardianship, conditions for the exercise of discretion, dower living expenses, undue oppression, arbitration, option of dissolution for serious disability, impotency, madness, the missing husband, Maliki rulings about missing husband, return of the missing husband, invoking Allah's curse, 3 simultaneous divorces. 8. The epilogue. 76. 9. Appendix 1. 77. A very important question answers. 10. Appendix 2. 83 divorce and separation laws in the West. 1. Forward. 2 things are essential for the survival of a society, viz. A comprehensive law framed to suit the peculiar needs of its cultural pattern, and secondly, the leadership that can enforce this law exactly in the spirit in which the law was framed. It is a pity that the Indian Muslims currently lack both these things. True, they possess laws preserved in the books, a legal code which fully suits Islamic civilization and culture and encompasses all social and cultural aspects, but in practice this legal code stands abrogated. Instead, their social affairs are being governed by a code of law that is totally un-Islamic in most of its social and cultural aspects, and to the extent to which it is Islamic, it falls short of the Islamic objectives. The government under which the Muslims are living today has practically divided their lives into 2 sections. In one section, it has subjected the Muslims, along with other communities of India, to the laws that have no compatibility with Islamic culture. And in the second section, the Muslims' right for the enforcement of Islamic law has, in principle, been conceded. But in practice, even in this section, the Islamic Sharia has not been rightly enforced. The so-called Muhammadan law enforced in this part is very different, both in letter and spirit, from the genuine Islamic Sharia. The enforcement of this law can in no way amount to the enforcement of the Islamic Sharia. This regrettable state of affairs has done great harm to the cultural life of the Muslims. The greatest harm done by it is the destruction of our family life. The lives of a large part of our population have been embittered and devastated. The marital relationship of man and woman is, in fact, the cornerstone of human culture. No human being, whether a man or woman, can step outside the ambit of the law designed to regulate the marital relationship. From childhood to old age, at every stage of life, this law influences human life. The rearing of a child is sure to bear the impress of the relationship of his parents. When he grows up to be a man, he will have to share life with a wife. When he reaches old age, his offsprings will have to be tied down by marital relationships, and his own peace of mind will be largely determined by the happy relationship between his son and his daughter-in-law, as well as between his daughter and his son-in-law. In short, the marital law is the most important and the most far-reaching of all social laws. Because of its basic importance, Islam formulated this law on extremely sound principles. In matters of marital relations, the Muslims were given a clear, comprehensive, and perfect law that can, in every respect, be called the best marital law of the world. But unfortunately, this was overtaken by the so-called Muhammadan law and was so badly deformed that it came to bear a very faint resemblance with the real Islamic marital law. Currently, the marital affairs of Muslims are governed by the so-called Islamic Sharia, which is neither clean nor comprehensive nor perfect. Its defects have influenced the cultural life of the Muslims, perhaps more adversely than any other law. There is hardly a fortunate family in India which is governed by this law, and life of someone of that family has not been ruined by this particular law. But the devastation of a life is a relatively minor thing. The great calamity is that this law has played havoc with the honor and good name of most of the Muslims. It has ruined their morals and their faith. It has let loose a flood of indecencies and apostasy into Muslim families that were considered to be the safest citadels of Islam and its culture. The damages resulting from the shortcomings of this law and the failures of the executive authority multiplied on account of two reasons. First, the lack of religious education. This has led to a sort of alienation of Muslims from the Muslim marital law that even well-educated Muslims are not aware of the common issues involved in this law. 1. The second cause is the influence of non-Muslim cultures. Due to this influence, several customs and superstitious rites and rituals that are alien to the Muslim marital law and its spirit have found their way into the marital relations of Muslims. Consequently, the true Islamic concept of marital relationship has escaped the minds of a great majority. In many cases, the Hindu concept prevails, reducing the wife to the status of a slave girl and elevating the husband to the status of a deity or a god. The marriage tie is unbreakable in practice, if not in principle. Divorce by the husband or by the wife is looked down upon as a stigma, which is avoided even if it becomes imperative just to save face, though this may involve covert acts far worse than divorce. To forestall a divorce, the dower has been raised to such heights that deters the husband from thinking of a divorce. If mutual hatred happens to develop, the man feels compelled to leave the woman in the lurch. Husband worship has come to be regarded as a source of pride and moral duty for the woman. Fear of social disapproval keeps her from dropping a hint of divorce even in the most trying circumstances. Even in the event of the husband's death, it is considered to be her moral duty to live for the rest of her life, like Hindu woman, in the name of her husband. The remarriage of a widow is considered to be shameful, not only for her, but also for her family. The people of new generation, on the other hand, who are under the spell of Western culture, go on quoting to suit their whims the Quranic verse, "Women deserve the same kind of treatment as men deserve from them." But if you quote the Quranic verse, "Men are a degree above women," their voices suddenly get hushed. And when they come to the verse, "Men are more powerful than women," they start hiding their helplessness to delete this verse from the Quran. They come out with all kinds of preposterous explanations of the verse, and their mode of explanation exposes their shame that their holy book should contain such a verse. The reason for this is that the equality of sexes publicized by Western culture has captivated their minds. They have lost the ability to comprehend the solid and infallible rational grounds on which Islam has based its social structure. These different reasons have combined to drag the family life of Muslims to depths that sadly contrast its former heights. The current laws and the executive machinery enforcing these laws are simply incapable of ironing out the complexities in the marital affairs of the Muslims, resulting from ignorance and the influence of foreign cultures. If anything, the complexities have increased. Because of ignorance, a section of Muslims believes that these evils have stemmed from deficiencies in the Islamic law. That is why they call for the compilation of a new code of law. The truth is that Islam possesses a perfect marital law that specifies clearly and equitably the rights of both husband and wife. Full provision has also been made for the protection and, in case of transgression, whether by husband or wife, for the restitution of these rights. There is no problem that has not been equitably solved. So Muslims are not in need of any law. All they need is that the Muslim marital law should be enunciated in its true form, and efforts be made to enforce it in the proper manner. This is by no means an easy task. To begin with, it is the duty of the ulama to give up blindly, following in the footprints of the past. They need to take into consideration the present-day circumstances and needs, and in this context, to compile the Muslim marital law in a way that fully solves the current complexities of the marital problems facing the Muslims. Muslims in general should also be educated in this law so that they can rid their social life of the unhealthy customs and concepts that have been borrowed from non-Muslim cultures. Only then they will understand the basis and the spirit of the Islamic law and will deal with their affairs accordingly. In addition to this, there must be a judicial system that has faith in this law. Its judiciary should have undergone the academic and moral training that enables it to enforce this law in its true spirit and not in the erroneous concepts of alien laws. From thinking of a divorce, if mutual hatred happens to develop, the man feels compelled to leave the woman in the lurch. Husband worship has come to be regarded as a source of pride and moral duty for the woman. Fear of social disapproval keeps her from dropping a hint of divorce even in the most trying circumstances. Even in the event of the husband's death, it is considered to be her moral duty to live for the rest of her life like Hindu woman in the name of her husband. The remarriage of a widow is considered to be shameful, not only for her, but also for her family. The people of New Generation, on the other hand, who are under the spell of Western culture, go on quoting to suit their whims the Quranic verse, "Women deserve the same kind of treatment as men deserve from them." But if you quote the Quranic verse, "Men are a degree above women," their voices suddenly get hushed. And when they come to the verse, "Men are more powerful than women," they start hiding their helplessness to delete this verse from the Quran. They come out with all kinds of preposterous explanations of the verse, and their mode of explanation exposes their shame that their holy book should contain such a verse. The reason for this is that the equality of sexes publicized by Western culture has captivated their minds. They have lost the ability to comprehend the solid and infallible rational grounds on which Islam has based its social structure. These different reasons have combined to drag the family life of Muslims to depths that sadly contrast its former heights. The current laws and the executive machinery enforcing these laws are simply incapable of ironing out the complexities in the marital affairs of the Muslims, resulting from ignorance and the influence of foreign cultures. If anything, the complexities have increased. Because of ignorance, a section of Muslims believes that these evils have stemmed from deficiencies in the Islamic law. That is why they call for the compilation of a new code of law. The truth is that Islam possesses a perfect marital law that specifies clearly and equitably the rights of both husband and wife. Full provision has also been made for the protection and, in case of transgression, whether by husband or wife, for the restitution of these rights. There is no problem that has not been equitably solved. So Muslims are not in need of any law. All they need is that the Muslim marital law should be enunciated in its true form and efforts be made to enforce it in the proper manner. This is by no means an easy task. To begin with, it is the duty of the ulama to give up blindly, following in the footprints of the past. They need to take into consideration the present-day circumstances and needs, and in this context, to compile the Muslim marital law in a way that fully solves the current complexities of the marital problems facing the Muslims. Muslims in general should also be educated in this law so that they can rid their social life of the unhealthy customs and concepts that have been borrowed from non-Muslim cultures. Only then they will understand the basis and the spirit of the Islamic law and will deal with their affairs accordingly. In addition to this, there must be a judicial system that has faith in this law. Its judiciary should have undergone the academic and moral training that enables it to enforce this law in its true spirit and not in the erroneous concepts of alien laws. This treatise has been written to meet this very need. In the following pages, we plan to set forth a full sketch of the Islamic marital law. The objectives of the law, its principles, and its mandates will all be discussed in due course. For explanation, we will quote, where necessary, the precedents handed down by the Holy Prophet, peace be upon him, and his companions, as well as the opinions of the great scholars of our early history. That will make the explanation of related issues easy. In the end, some proposals will be made that will help solve, to some extent, the difficulties faced by Muslims in their marital affairs. In fact, the right and effective remedy for these difficulties lies in the establishment of an Islamic state and an Islamic judiciary. But as the barest minimum, we want to discuss even the skeletal forms which can, in a correct Islamic way, remove the evils plaguing the marital affairs of the Muslims. That will enable people who are striving to solve these problems to avoid moving in the wrong direction and to adopt a way that is compatible with the Sharia. References. 1. It is, for example, the result of ignorance that Muslims in general know only one mode of pronouncing divorce, i.e., pronouncing the 3 divorces all at once. Even the person who writes down the divorce deed pens down 3 simultaneous divorces. Islam looks upon this as a deviation and a serious sin. This leads to a host of legal complexities. If people realize that a single pronouncement of divorce serves the same purpose as 3 pronouncements at a time, the possibility of reconciliation before the expiry of the prescribed time remains, and there remains the option of reunion after the expiry of the prescribed time. That could save many homes from breaking up and could also save countless people from indulging in falsehood, trickery, and violation of law. 2. Objectives of the marital law. Before going into the details of the marital law, it is necessary to understand its objectives. The objectives of a law are its core. In order to achieve the objectives, principles are prescribed and then mandates are formulated to serve the principles. If mandates are given without comprehending the objectives, there is a possibility of the mandate being applied to a particular issue in a way that forfeits the very essence of the law. In the same way, a person who is unaware of the objectives of a law will not be able to follow it in the true spirit of the law. So we begin with the explanation of the objectives for which Islam has laid down its marital law: preservation of morality and chastity. The first objective of the Islamic marital law is the preservation of morality. Islam denounces fornication as illegal. It urges both sexes of humanity to subject their relationship to a code of law which protects the morality of man against indecency and immodesty, and God's civilization against chaos. That is why the marriage tie has been termed fortification by the Quran. Hisn means fort in Arabic, and ihsan means fortification. A person who marries gets fortified. In other words, he builds a fort for himself. The woman he marries is called the fortified one. Marriage provides her with a fort built for the satisfaction of her sexual desires and the protection of her morality and chastity. This simile clearly shows that in Islam, the first objective of marriage is the preservation of morals and chastity. The first step of the marital law is to strengthen the fort built by marriage for the preservation of a priceless possession. Note the laws of the Quran. Excepting the women made unlawful for you, all other women are lawful for you, provided you seek them with your property in marriage, not for committing fornication. 4:24. Marry them with the permission of their guardians and give them their dowers justly, so they become chaste women, not fornicating nor secretly receiving paramours. 4:25. And so are the believing chaste women lawful for you, as well as the chaste women from among those who have been given the book before you, when you give them their dowers, taking them in marriage, nor fornicating, nor taking them as paramours in secret. 5:5. A critical look at the above verses makes it clear that from the Islamic point of view, the most important thing about the marital relationship is the fullest and most effective preservation of morality and chastity. This objective should be achieved even at the cost of any other objective. No other purpose should be served at its cost. Husband and wife are tied together simply with the sole aim of enabling them to satisfy their natural passions within the limits set by Allah the Almighty. However, if the marriage tie leads to circumstances where the violation of the limits set by Allah is feared, it is far better to stick to these limits at the cost of the marriage tie, rather than retain it at the cost of Allah's limits. That is why those who declare an intention to abstain from their wives have been commanded not to do so for more than 4 months. In case they overstep this limit, they lose their right to retain the marriage tie. If they were allowed to keep their wives suspended indefinitely, the inevitable outcome would be that the demands of their inborn passions might force the women to violate Allah's limit. That is something totally unacceptable to the divine law. In a like manner, men who marry more than one wife are warned by the Quran, do not lean exclusively to one wife, leaving the other one in the lurch. This command also warns men not to drive women into a desperate situation which forces them to violate Allah's limits. In such a situation, it is better to dissolve the apparent bond of marriage rather than retain it, and the women should get the freedom to marry someone else. The woman has been granted the right to demand divorce only to cope with such situations. Forcing a woman to live with a man with whom she is no longer happy or who cannot give her peace of mind places her in a situation that threatens to override Allah's limits. It is because of this that a woman has been granted the right to get rid of the marriage tie on payment to her husband, the dower she received, or even something more or less, as the two of them may agree upon. A detailed discussion of these clauses of the Islamic law will be taken up later. The matter has been touched upon here just to stress the supreme importance of morality and chastity in the eyes of the Islamic law. This law does its best to strengthen the marriage tie in all possible ways, but when the retention of this bond becomes a threat to morality and chastity, Islam considers it necessary to save these precious values even at the cost of the marriage bond. This point needs to be fully grasped if the forthcoming clauses of the Islamic law are to be understood and enforced in the spirit of the Sharia, love and compassion. The second objective is to base the marital relationship between the two sexes on love and compassion so that the two of them together can promote the tasks that human civilization and culture seek to accomplish through marriage. Love and compassion not only enable the spouses to lead a happy and peaceful family life, but also give them the strength needed for the promotion of higher cultural values. The Quran has described this objective in a tone that suggests that in the eyes of Islam, the very concept of marriage is the concept of love and compassion. The spouses have been created that they may enjoy peace in each other's company. And of his signs is that he created mates for you from yourselves, that you might find peace of mind in them, and he put between you love and compassion. Surely there are signs in this for a people who reflect. 30:21. In another chapter, the Quran says, He it is who created you from a single soul, and of the same kind he made his mate, that he might find comfort in her. 7:189. Still in another chapter, the marital tie has been described thus: They are an apparel for you, and you are an apparel for them. 2:187. The last verse compares the spouses to an apparel for each other. Dress is closer to the human body than anything else. It not only covers the human body for modesty, but also protects against inclement weather. The simile of an apparel has been used to emphasize that in essence the marriage tie is just like the relationship between the human body and the dress it wears. The minds and souls of the spouses have to be so close a person that they provide a cover for each other. They should fight off all evil forces that pose a threat to the honor and morals of the mate. Such are the implications of love and compassion. This is the real meaning of the marital relationship. And if this is missing, the marriage tie is like a lifeless corpse. This objective permeates all laws framed by Islam about marital relationship. The spouses have to live together amicably and in an atmosphere of love and harmony. They should generously respect each other's rights. In case they are unable to do this, their separation is better than their union. A marital bond which is devoid of love and compassion is like a dead body, which, if left unburied, is sure to putrefy and pollute its surroundings. This explains the Quranic verdict. And if you live in amity and are mindful of your duty, surely Allah is ever forgiving, merciful. And if they separate, Allah will render both of them free from want out of His ample resources. 4:129, 130. The point is stressed even more forcefully in other chapters. Then keep them in good fellowship or release them with kindness. 2:229. Retain them with kindness or release them with kindness. 65:2. And treat them kindly. 4:19. retain them in kindness, or release them in kindness, and do not retain them just to torment them and to rob them of their rights. And whoso does this, he surely wrongs his own soul. 2:31. And in your mutual dealings, do not forget to be generous. 2:37. Islam does not want divorce to be a hasty and impulsive act. Hence, the provision for 3 pronouncements of divorce. Before the 3rd pronouncement, the husband has the right to retain his wife, provided he does so in good faith. The marriage tie can stay intact only if it is sustained by love and compassion. The husband is not allowed to retain his wife with a view to tormenting her and keeping her suspended. The Quran is explicit on this point, and their husbands have a better right to take them back if they want this in good faith. 2:28. Muslims, both men and women, are forbidden to have marital relations with non-Muslims who are not believers in the scriptures. The simple reason is that their religion, their thinking, their civilization and culture, and their way of life are so different from those of the Muslims that it is impossible for a true Muslim to develop deep love and integration with them. Even if, despite differences, the two are tied together in marriage, the relationship will be only carnal. It will not be a truly cultural and harmonious relationship. If it is not, the love and compassion are sure to do more harm than good, both to Islamic culture and to the Muslim partner of the union. The Quran bears testimony to this. And do not marry the idolatresses until they believe, and certainly a believing maid slave is better than an idolatress, even though you like her. Nor give believing women in marriage to idolaters until they believe, and certainly a believing slave is better than an idolater, even though he pleases you. 2:221. As for the Jews and Christians, people of the scriptures, Islamic law allows marriage with Jewish and Christian women because Muslims share some cultural factors with them. L. Despite this permission, Islam has discouraged such marriages. Ka'b bin Malik wanted to marry a woman from among the people of the book. The Holy Prophet, peace be on him, forbade him from this. His reason was that the woman would not be able to provide him with the required degree of love and compassion, which is the essence of the marriage tie. The well-known companion Huzaifa wanted to marry a Jewess. Omar, the second caliph, wrote to him to drop the idea. Ali and Abdullah bin Omar openly denounced marriage with Jewish and Christian women. In support of his opinion, Ali quoted the Quranic verse, "You will not find a people who believe in Allah and the last day, loving those who oppose Allah and His Messenger." 58:22. Ali clinched his argument by asking, what is the use of marriage if there is no love between husband and wife? Compatibility. The intention of the Islamic Sharia is that the marriage tie should be established between a man and a woman who, because of their social background, are likely to develop a bond of love and compassion. Where this likelihood does not exist, it is not desirable to arrange a marriage. That is why the Holy Prophet, peace be upon him, declared it necessary, or at least advisable, that before marrying a woman, the man should take a look at her. When someone from among you seeks the hand of a woman in marriage, he should, as far as possible, take a look at her so that he can be sure that she has attraction for him. Abu Dawud. This accounts for Sharia's insistence on compatibility. It does not approve of marriage between incompatible partners. If a man and a woman belong to families that share close or partial similarities in their views on morality, religion, social behavior, and the day-to-day household management, they are more likely to develop and strengthen a bond of love and compassion. Their marriage tie can be expected to bring the two families still closer. On the other hand, if the man and the woman come from families that have little in common, the greater likelihood is that both in their domestic life and in their emotional response, the couple feels love for each other. There is little hope of their families getting any closer. This is the essence of the compatibility clause in the Islamic law. All that has been said so far proves that after the preservation of morality and chastity, the next most important thing in the Islamic marital law is the bond of love and compassion between the husband and wife. As long as there is hope that their relations will continue to be governed by this bond, the Islamic law strives its most to protect the marriage tie. However, when love and compassion have been replaced by apathy, frustration, hatred, and disgust, the law prefers to do away with the marriage tie. This point is worth keeping in mind. People who lose sight of this pertinent point and seek to apply the principles of the Islamic law to a particular case commit blunders at each step that are incompatible with the real objectives of the law. References. 1. Muslim women are not allowed to marry men from among the people of the scripture. Feminine nature being shorter and not more supple, a Muslim lady with a non-Muslim husband in a non-Muslim society is more likely to adopt their way of life and less likely to influence their thinking. If she refuses to be influenced by the surrounding culture, the marriage tie is sure to be reduced to a carnal relationship. She will be unable to develop love and compassion for her husband, nor can she build any useful cultural contact with the non-Muslim family and the non-Muslim society. 3. Principles of the law. Having discussed the objectives of the law, we now take a look at the principles on which the Islamic marital law has been compiled. Unless the principles are thoroughly grasped, it is difficult to apply correctly the mandates of the law to particular cases. The first principle in the Islamic law, from which stem out many of the mandates, is that in marital life man is placed a degree above the woman. The following verse from the Quran elaborates the extent of the degree. Men are the maintainers of women with what Allah has made some of them to excel others, and because they spend out of their wealth. So the good women are obedient to their husbands and guard their rights in their absence. 4-34. It is out of place to discuss here why man has superiority over the woman or why he has been made her maintainer. Qawam also means guardian, protector, manager, supervisor. This discussion does not belong to law, it belongs to sociology. Sticking to the limits of the topic under discussion, it is enough to point out that for the smooth running of the household affairs, one of the partners has, in any case, to be the manager or the executive head. If both of them stand at an equal footing and possess equal powers, chaos is sure to result. That is what is actually happening in nations that have tried to grant practical equality to husband and wife. Islam has taken due account of human nature. It has chosen one of the partners as the manager and the other one as subordinate. For the ruling function, it has chosen the one who is naturally fit for the job. The duties of man. The code of married life promulgated by Islam assigns to man the role of the head of the family. This role brings with it the following duties. I, dower. The husband has to pay the wife a dower. This is the price of the marital rights he has on her. The Quranic verse quoted above makes it clear that though man deserves by his nature to be the manager, in practice he is elevated to this role as a reward for the money he spends in the form of dower. Other verses also clarify this point. And give women their dower cheerfully. 4. Excepting the aforesaid women, all other women are lawful for you, provided you seek them in return for your property, taking them in marriage and not for fornication. So in return for marital rights, pay them their dower according to the appointed time limits. 4:24. Marry these maids with the permission of their masters and pay them their dower in a proper manner. 4:25. Lawful for you are the chaste women from among the believers, and chaste women from among those who have been given the book before you, after you have given them their dower. 5. It is binding upon the husband to abide by the agreement regarding the dower, concluded at the time of marriage. In case he refuses to abide by it, the woman has the right not to allow him to touch her. There is no way out for the man. The wife, however, may of her own free will grant him some time, or in view of his indigence, may remit a part of or the whole of the amount due to her. She may even give up her claim as a token of compassion. But if they, wives, of themselves be pleased to give you a part of the dower, take it cheerfully. 4. And there is no blame on you about what you mutually settle after the dower agreement has been made. 4:24. Isale, livelihood. The second duty of the husband is to bear the living expenses of the wife. Islam has clearly demarcated the sphere of work for the husband arid the wife. A woman's duty is to stay at home and take care of the household chores. Stay in your homes is the Quranic commandment for women. The man is supposed to work for a living and provide the necessities of life for the family. This is the second factor that elevates the husband a degree above the wife. This duty is implicit in man's guardianship status. Qawam is a person who looks after and takes care of a thing, and by virtue thereof has an authority over it. The Quranic verse justifies man's higher status on the ground that he spends money. The spending includes dower as well as the living expenses. If the husband fails to discharge this duty, the law will force him to do so. In case of refusal to comply with the legal requirement, even if it is because of indigence, the court will dissolve the marriage. As for the amount of living expenses, the assessment has to be based on the means of the man, not on the demand of the wife. The Quranic commandment in this regard is, from the wealthy man according to his means, and from the poor man according to his means. A man of limited means cannot be made to pay living expenses beyond his resources, nor can a man of ample means be allowed to pay an amount below his financial status. 3. Abstention from cruelty. The third duty of man is not to use his superior position as a means of oppressing his wife. Oppression can take several forms, like leaving alone. This means depriving the wife of sex not on grounds of health, but just to punish or torment her. The maximum time allowed by the Islamic law for such punishment is 4 months. Before the expiry of the 4 months, the husband must resume sexual relations. On the expiry of the time limit, separation must take place. The Quran says, those who swear to leave their wives alone have to wait 4 months. If they resume sexual relations, Allah is forgiving, merciful. But if they decide on a divorce, then Allah is surely hearing, knowing. 226. Some jurists are of the view that taking a vow is a necessary part of the case if it is to be covered by the above verse. If no vow is taken and the husband is just angry with the wife, the case will not fall in this category and the marriage tie will stay intact, even though the man may not touch the wife for 10 years. I do not agree with this view. My reasons are, first, when the Quran pronounces a commandment about a particular case, it does not mean that it covers just that particular case. The point becomes amply clear when we consider the Quranic commandment making the stepdaughter unlawful for a man. The words used by the Quran are, the foster girls who have grown up in your lap. This would seem to suggest that only those stepdaughters have been unlawful who were just babies when their mothers married their stepfather. No jurist has even taken this position. All agree that a stepdaughter is unlawful for a stepfather, even though she be a grown-up woman when her mother married the man. In the same manner, the Quranic words, those who swear not to touch their wives, do not imply that the verse is applicable only to cases where an oath has been taken. Secondly, it is almost a unanimously accepted principle of Islamic jurisprudence that when a case seems to be covered by no commandment, it should be placed in a category where a commandment exists, provided the basic reasons behind this commandment are the same as the basic issues involved in the uncovered case. Let us see why the lawgiver has prescribed a period of 4 months for the man who has vowed not to touch his wife, and why he has been told that if he does not resume sexual relations within the prescribed time, he shall have to dissolve the marriage tie. Can anyone give a reason other than the fact that going without sex for more than 4 months is injurious for the woman and the lawgiver wants to save her from ill effect? This commandment is followed a little further by the commandment, do not retain them just to do them injury, for then you exceed the limits. In another verse, quoted in the previous chapter, the lawgiver commands, do not lean exclusively to one wife, leaving the other one suspended. These broad hints clearly indicate the lawgiver's disapproval of keeping a woman tied down by the marriage and then leave her suspended just to torment her. No other reason can be ascribed for the 4-month time limit, so when a husband purposely cuts off sexual relations with his wife, even without taking a vow, why should the case not be covered by the verse which speaks of swearing by the husband? After all, the injury caused to the wife is the same whether the man swears or not. Can any sensible person imagine that a husband who vows to refrain from sexual relations causes injury to the wife, but no injury will be caused if he does not swear, even though he may not touch her for the rest of his life? Thirdly, the most important objective of the Islamic marital law is the preservation of morals and chastity. If a man is disgusted with one wife and marries another one, and thus saves himself from evil ways and evil glances, how can a woman who has been permanently deprived of sex by her husband protect her morals? Does it stand to reason that the wise lawgiver should provide for the protection of her morals if the husband is under an oath not to touch her, and if the man is not under any oath, the threat of immorality should be left hovering indefinitely over the woman's head? On the above grounds, I favor the ruling of the Maliki school of thought, which asserts if the husband withholds sex with a view to injuring the wife, the case will fall under abstention because of an oath, even though the man be under no oath. That is because the intention of the lawgiver in the latter case is to prevent injury to the woman. This cause also exists in abstention with swearing. There is a difference of opinion about the implications of these words if they decide on a divorce. Osman bin Affan, Zaid bin Sabit, Ibn Masud, and Ibn Abbas are of the view that the expiry of the 4 months period is proof of the husband's resolve to divorce. On the expiry of the period, he loses the option to restore marital relations. A saying of Ali and Ibn Omar conveys much the same sense, but another saying of the last two companions, that has the support of Hazrat Aisha, too, states that a notice has to be served on the husband either to restore the marital tie or to dissolve the marriage. But a careful look at the words of the verse suggests the plausibility of the first view. The verse clearly sets a 4 months limits. That means that the right of restoration can be exercised only within this limit. On its expiry, there is no way left except divorce and separation. If the man is given the right to restore marital relations after 4 months, it will amount to the extension of the time limit set by the Book of Allah. Injury and oppression. If the husband develops a dislike for the wife, has no intention to keep her, and still retains her just to torment and oppress her, or if he goes on divorcing her and after 2 pronouncements keeps restoring the marital bond, the Quran strongly condemns his behavior as tyrannical. And do not retain them for injury so that you exceed the limits. And whoso does this, he indeed wrongs his own soul. And do not take Allah's commandments for a mockery. 2:31. As for the interpretation of the words of a law which runs contrary to the objectives and the spirit of the law, amounts to making a mockery of the law. After the pronouncement of 1 or 2 divorces, the husband has been given the right to restore marital relations only to facilitate reconciliation, born after tempers cool. This is a safety valve mercifully granted by Allah as a check on the volatile human nature. However, if someone takes undue advantage of this concession and indulges in the ugly game of pronouncing divorces and going back on them again and again, it amounts to making the divine concession a plaything. He neither wants to keep her, the woman, nor wants to let her marry another man. No true believer can ever think of making such a mockery of Allah's commandments. Anyone who retains a woman just to torment and oppress her may concoct all kinds of ways to cause her mental and physical torture. If he comes from the lower social strata, he may resort to filthy language and beating. If from the upper strata, he may use more subtle ways of disgracing and torturing her. All these acts, whether crude and subtle, amount to injury and oppression and are forbidden by the Quran. A husband which hands out such treatment to his wife exceeds Allah's limits. His wife is entitled to get rid of him with legal help, not being just to wives. When there are several wives, it amounts to oppression to incline exclusively to any one of them, leaving the second wife or the rest of the wives suspended. The Quran explicitly declares this as unlawful. Do not lean exclusively to one of them, leaving the rest of them suspended. 4:129. Polygamy has been permitted by the Quran on the condition that justice be done to all wives. If a man is unable to do justice, he has no right to avail of this conditional permission. The verse permitting polygamy clearly warns that a man who fears that he will be unable to do justice should be content with only one wife. But if you fear that you will be unable to do justice, then have only one wife or the slave you possess. This is more equitable, lest you should deviate from the path of truth. 4:3. Imam Shafi'i suggests that the implication in lest you should deviate is that more wives will mean too many children to be looked after properly. But the meaning of the Arabic word awl does not lend support to this interpretation. Awl means to lean, and the word is used to indicate injustice and oppression. Ibn Abbas, Hassan, Mujahid, Sha'abi, Ikrimah, Qatada, and others agree that the meaning of la ta'ulu is do not deviate from the path of truth. This verse of the Quran proves that if a man does not do justice to his wives and leans towards one of them at the cost of the rights of the others, he is an oppressor. He has no right to avail of the permission for more than one wife. The law should force such a man to have only one wife. The rest of his wives should have the legal rights to get rid of him. Referring to justice, the Quran has made it clear that so far as emotional attachment is concerned, it is beyond a man's nature to practice equality in this regard, nor is he under obligation to do this. But he is certainly under obligation to practice equality among his wives in the matter of living expenses, social contact, and other marital relations. The law can intervene in the above-mentioned three forms of oppressions by the husband. In addition to these, other problems arise in the mutual relations of the spouses. They stem from the lack of love and compassion and are outside the ambit of the law. For coping with such problems, the Holy Quran has given men sound ethical advice. They are told to be kind, loving, and generous towards womenfolk. Islamic marital law frowns upon unhappy and broken family life. As long as the marriage tie is there, the wife has to be well treated. In case the tie breaks, she should be released with kindness. Good treatment cannot be enforced by law. The little problems of day-to-day life are beyond the reach of law. However, the Islamic marital law seems to place the greater burden of maintaining the climate of fair play, love, and compassion on the shoulders of the husband. Rights of the husband. The responsibilities placed on the man because of his role as the guardian have been discussed above. Now we look at rights stemming from this role. I. Vigilance in his absence. The first right the husband has on the wife is that she should keep a firm vigil in his absence over everything that belongs to him. In the words of the Quran, good wives are obedient and keep a vigil under Allah's protection when the husband is absent. 4:34. During the husband's absence, a good wife keeps a watchful eye on everything belonging to him and placed in her charge as a trust. She has to protect not only his property and his secrets, but his honor, his children, and the purity of his lineage. Any failing on her part to discharge this all-important function entitles the husband to use powers that will be discussed ahead. Obedience. As stated in the above verse, good women have also to be obedient to husbands. The details of this general commandment have been given by the Holy Prophet, peace be on him. Surely you have right on them not to let in anyone whom you dislike. The wife has no right to give away anything from his home without his permission. In case she does this, the man gets the reward for the charity and the woman will bear the burden of sin. Nor can she leave the home without his permission. When the husband is not away, the wife should not keep even a single day's optional fast without his permission. This does not apply to fasting in Ramadan. The best wife is the one who is attractive in your eyes, who carries out your instructions, and when you are absent, keeps a watchful eye on your right to your property and your right on her. The general mandate for obedience has only one exception, i.e., if the husband tells her to sin, she can refuse to obey, rather should refuse to obey him. If, for example, the husband tells her not to offer the obligatory prayers, or not to keep the obligatory fasts, or to drink liquor, or to give up the prescribed veil, or to indulge in indecencies, she is duty-bound to reject such orders. No one has the right to force anyone to violate the commandments of Allah, the Almighty. With this exception, the wife must obey her husband in all cases. In case of disobedience, the husband will have the right to use his powers, as discussed below. Man's powers. The Islamic marital law makes man the manager of the family affairs. It places on him the obligation of paying the wife a dower and her living expenses. It makes him responsible for her care and well-being. It is only natural that he should be given powers for the orderly running of the household, protection of its moral behavior, social harmony of the home, and guarding against trespass on his own rights. The Islamic law clearly enunciates these rights and also defines the limits within which they can be exercised. Counseling, admonition, punishment. In case the wife disobeys the husband or does away with any of his rights, the man should first counsel her. If this fails to be effective, he has the right to be reasonably stiff in dealing with her. And if this too goes unheeded, he may give her light beating so that she sees reason to obey him. As for the women from whom you fear refusal to protect your rights, counsel them and leave them alone in their beds and chastise them. But if they obey you, take no stern action against them. 4:34. In the above verse, leaving alone in beds means refraining from sex as a punishment. But such punishment, as has already been discussed, cannot be extended beyond the natural limit of 4 months. A woman who is so reckless and wild-tempered that she angers her husband to the extent of not sharing the bed with her is certainly not a normal woman. And if even this punishment fails to bring her to senses, and she persists in her disobedience. Knowing well that at the end of 4 months her husband will be under legal obligation to dissolve the marriage tie, she deserves to be divorced. The 4 month period is enough to reform a person. Persistence in hostility for 4 months is evident that she is devoid of the ability to reform herself. She certainly is unable to live in harmony with the present husband. The continuance of their marriage tie threatens to kill the very objectives for which they were tied together. Such a situation may drive the husband to seek satisfaction of the sexual urge in extramarital relations. The wife, too, could easily slip into the same snare. Whenever one of the spouses is overly stubborn and ill-tempered, the relationship of love and compassion is hard to sustain. Imam Sufyan Sori has given a different meaning to the words of the sentence, "Leave them alone in the beds." He suggests that the meaning is, "Tie them down in homes," but the words of the verse do not warrant this meaning. The use of the word bed clearly indicates the exact meaning the Quran wants to convey. The second punishment that has been permitted only in very serious cases is to give a beating. But for this, the Holy Prophet, peace be on him, has laid down the caution that the blow should not be severe. If she disobeys some reasonable order of yours, give her a beating that is not very painful. Do not strike on the face and do not use filthy language. Hadith. The husband has been permitted to inflict these two punishments, but as cautioned by the Holy Prophet, peace be on him, punishment is permissible only when a legitimate right of the man has been violated. It would be foolish to insist that every order, whether reasonable or not, should be carried out, and in case of non-compliance, the woman should be punished. Also, there should be some balance between the fault and the punishment. One of the cardinal principles of the Islamic legal code is, he who wrongs you should be wronged by you to the extent to which you have been wronged. It amounts to injustice to inflict a punishment out of proportion to the wrong done to somebody. Where counseling can suffice, it will be inadvisable to cut off relations. Where cutting off the relationship suffices, it will be injustice to stop sharing the bed. And where withholding sex is enough, it will be cruel to inflict beating. Beating is the severest of punishments and is permissible only in very serious and unbearable misconduct. In this case, too, the limit prescribed by the Holy Prophet has to be borne in mind. If the limit is overstepped, it will amount to cruelty on the man's part. That will give the woman the right to get legal help against him. T. Divorce. The second right given to the man is that he can divorce the wife with whom he cannot pull on. Since he gets marital rights by spending money on her, it is he who has been granted the powers to give up these rights. This right cannot be given to the wife. If she were to be given this right, she would become fearless and overbold and easily violate the man's rights. It is evident that if a person buys something with money, he tries to keep it as long as he can, and he parts with it only when he is left with no options. But when a thing is purchased by one individual and the right to cast it away is given to another, there is little hope that the latter will protect the interest of the buyer who invested the money. Investing man with the right to divorce not only amounts to the protection of his legitimate rights, but also ensures to check the growth of the divorce rate. References. 1. This kind of an agreement to pay dower is termed as the deferred dower. The current practice is that at the time of marriage, a huge amount is specified as the dower in a document of marriage. The general comment is, this is just a formality. Who is going to ask for the payment? How very unfortunate. In the light of the above quoted Quranic verses, a marriage solemnized with the ill-conceived intention of non-payment of the dower is a nullity in the eyes of Allah. A truly deferred dower must specify the time within which the dower is payable. Where no time is specified, the dower is payable on demand. Some ignorant jurists are of the opinion that such a dower is payable on the death of the husband. This is, to say the least, strange logic, unsupported by the Quran or the Sunnah. 2. Ahkamul Quran by Ibn Arabi, Volume 1 I, page 76. Hidayatul Mujtahideen by Ibn Rushd, Volume 3, page 88. 3. It is a controversial issue whether this should be just one divorce or 3 divorces providing for restoration. For some people who, like Western ways, want to take away the right of divorce from the husband and hand it to the court, this has been done in Turkey. But this practice is contrary to the Quran and the Sunnah. In its discussion on the law about divorce, the Quran has consistently ascribed the act of divorce to the husband. If you divorce the woman, if he divorces her, if he decides on a divorce, etc. Quranic verses provide clear testimony that it is the husband who has been invested with the power to divorce. In the second chapter, the Quran unequivocally declares the marriage tie is in his hands. 2:37. In the face of this mandate, who is there to take this right away from his hand and place it in the hand of a judge? There is a hadith on the authority of Ibn Abbas in Ibn Majah to the effect that a man came to the Holy Prophet and complained that his master had married his slave to him and now wanted to separate her from him. At this, the Prophet of Allah delivered an address to the people. O people, what is this happening around us? One of you married his maid to his slave and now wants a separation between them. The right of divorce belongs to the husband. This tradition may not be very reliable, but it has the strong support of the Quran. So, both according to the verdict of Allah and His Messenger, it is not lawful to deprive the husband of the right to divorce and hand over this right to the court. This step is wrong even on grounds of common sense. This can only lead to exposing shameful domestic affairs in courts as is happening in Europe. 4. The second principle. The second principle of the Islamic marital law is that the bond of marriage should be strengthened as long as possible, and utmost efforts should be made to keep the marital union intact. However, when all hope of containing the love and compassion between them is gone and the marriage becomes a danger to the objectives of the law, no insistence should be made on keeping the unwilling partners tied together despite their mutual hatred, dislike, and distrust. In such a situation, it is in their interest as well as in the interest of the society that their separation be permitted. In this matter, the Islamic law has maintained a balance between its concern for the demands of human nature and its regard for the preservation of the social good. This balance has no parallel in any other law of the world. Islam does seek to make the marriage tie strong, but unlike Hindu or Christian law, it does not make it unbreakable, even though the married life of the spouses may have degenerated into intolerable misery. So Islam keeps the door of separation open, but not so wide open as it is in the present-day Russia, USA, and most other Western countries, where the marital tie is free from all restraints. In those countries, the weakening of the marriage bond is the source of all disruption in family life. The three modes of separation allowed under this principle are I. Divorce 2. Kula or divorce claimed by wife tatei, decree of the court, conditions for divorce. In the technical language of the Sharia, divorce means the separation which the husband wants as a matter of right. He is free in the exercise of this right. He may, whenever he likes, relinquish the marital rights obtained in exchange for the dower. However, the Sharia strongly disfavors divorce. In the words of the Holy Prophet, in the eyes of Allah, it is the most hateful of the lawful things. Another saying is, marry and do not divorce, for Allah does not like men and women whose only aim is the satisfaction of their sexual lust. Though the husband is free to exercise the right to divorce, he has been placed under checks which allow him to use this right only as a last resort. The verdict of the Quran is that a man should do his best to pull on with his wife even though he does not like her. Treat them, women, well, though you dislike them. Maybe you dislike a thing and Allah has placed in it great good for you. Baqarah 19. However, if it becomes impossible to pull on together, the right to divorce can be exercised, but it should not be a headlong plunge. There should be 3 divorces, spaced by 3 periods of menstruation. By the time of the third cleansing, there will be plenty of time for second thoughts. Some way of reconciliation may, after all, be found. A pleasant change may come in the attitude of the woman, or the man may change his mind. But if even at the end of 3 periods of waiting and cool thinking, the husband feels convinced that he must leave the woman, he may divorce her at the end of the 3rd period, or he may let the period pass by without restoring conjugal relations. 1. Divorce is to be pronounced twice, then either keep them in kindness or release them in kindness. 2. 229. And the divorced women should keep themselves in waiting for 3 menstrual courses, and their husbands have a better right to take them back during this period if they desire reconciliation. 2. 228. Another significant Quranic injunction is that during the period of waiting, the woman should not be sent away but should be retained, in the hope that living together might unite hearts. O Prophet, when you divorce women, divorce them for their prescribed period and calculate the period and fear Allah, your Lord. Do not turn them out of their homes, nor should they themselves leave, unless they commit an open indecency. And these are the limits set by Allah. And whoso goes beyond the limits of Allah, he indeed wrongs his own soul. You do not know that Allah may after this bring about reconciliation. So when they have reached their prescribed period, retain them in kindness or release them in kindness. 65, 1, 2. Divorce is not permissible during the course of a menstrual discharge. If divorce becomes a necessity, it should come during the period of purity. There are two reasons behind this injunction. First, during the course of menstrual discharge, women generally become glum and ill-tempered. Changes in their body chemistry provoke them to do things which they would not do in normal days. This is a medically proved fact. That explains why disputes arising between husband and wife during the course of a menstrual discharge are not considered a sufficient ground for divorce. Secondly, during this period, the bodily contact, which is an important factor in the mutual attachment of the spouses, is suspended. This can breed estrangement between them. But when the temporary barrier is no more, the serene intimacy of conjugal relations is likely to brush off from the mind any lurking thoughts of separation. The spouses are united together once again into an integral whole. It was on these grounds that the Holy Prophet, peace be on him, disapproved of divorce during the course of menstrual period. Abdullah bin Omar divorced his wife during menstruation period. Hazrat Omar reported the case to the Holy Prophet. He felt upset and told Omar to direct his son to retain his wife and divorce her after she was cleansed. Another report states that the Holy Prophet, peace be on him, reprimanded Abdullah for this act of his and explained to him the right procedure thus: Ibn Omar, you adopted a wrong procedure. The right way is to wait for the period of cleansing, then let there be a pronouncement of divorce at the beginning of the next cleansing. When she gets cleansed the third time, you may divorce her or retain her. At this, Abdullah asked, Messenger of Allah, if I had made the three pronouncements of divorce simultaneously, could I still have the right to retain her? The reply was, no, she must be separated and you have sinned. This ruling of the Holy Prophet conclusively proves that the simultaneous pronouncement of three divorces is a sin. The simple reason is that this act runs counter to the values of the Islamic law. It oversteps the limits of Allah, respect for which has been strongly stressed by the Quran in verses 1 and 2 of chapter 65, 2. It is reported of Omar bin Khattab that if someone came to him with the report that he had made three simultaneous pronouncements of divorce, he would give the wretch a beating and would declare that he and his wife stood separated. Ibn Abbas was asked what he thought of the man who had made three simultaneous pronouncements of divorce. His reply was, he has disobeyed Allah, his Lord. His wife stands separated. Hazrat Ali summed up his views on the problem thus: if people had fully kept in mind the limits set by Allah for divorce, no one could have any cause to repent after the separation of his wife. On top of all the hurdles for pronouncing divorce, there is the last and the toughest, in which a man who stands separated from his wife by an irrevocable divorce cannot remarry her. If she marries any other man, has conjugal relations with him, and then the man, of his own free will, divorces her, only then can she remarry her former husband. So if a man makes the third pronouncement of divorce, the woman is no longer lawful for him unless she marries another man. 2:30. This condition is so hard that it will make a man think 100 times before he makes the third pronouncement of divorce. He will divorce her only if he is fully convinced that he can never pull on with the woman. To get around this tough condition, some people have devised a trick. If after pronouncing an irrevocable divorce, someone regrets the decision and wants the woman back, a spurious marriage is arranged between her and another man, who, in return for the money he is given, undertakes to divorce her without touching her. But this trick cannot escape the clear ruling of the Holy Prophet, peace be on him. A divorced woman is not lawful for the first husband unless she marries another man and he has shared bed with her. The Messenger of Allah cursed the man who gets his divorced wife married to another man, only with the purpose of making her lawful for him. He also cursed the man who solemnizes such a marriage. He likened both of them to hired bulls. As a matter of fact, such sham marriages are only a flimsy cover for fornication. It is surprising that some of the ulama provide legal justification for such marriages. Kula. Man has been granted by the Sharia the right to divorce his wife, whom he dislikes, and with whom he can in no way pull on. In the same way, the Sharia has given the woman the right to demand separation from her husband, whom she dislikes. The mandates of Sharia on this matter have two aspects, namely the moral aspect and the legal aspect. The moral aspect of Kula, like the moral aspect of divorce, is that it has to be used as a last resort, and not for the fulfillment of carnal desires. Kula and divorce should not be made playthings. The point has amply been made clear by the Holy Prophet, peace be on him. Allah does not like sex-hungry men and sex-hungry women. Allah's curse falls on the sex-hungry man who is prone to divorce women. A woman who obtains a separation from her husband without any misbehavior on his part stands cursed by Allah, by the angels, and by humanity. Women who make kula a plaything are hypocrites. However, the law which is concerned with the demarcation of people's rights does not discuss this aspect. Just as it gives man the right to divorce as a husband, much in the same way it gives woman the right of kula, this makes it possible for both of them to get rid of the marriage tie, if such a need ever arises. The purpose is to forestall a situation where there is hatred in the hearts, the objectives of marriage remain unfulfilled, the marriage tie has become a curse, but still the two spouses are under compulsion to stay together because they feel that there is no way out. As for the improper use of rights by either one of the spouses, all that the law can do is to lay down reasonable and workable restraints. However, the proper or improper use of a right depends, for the most part, on the discernment, integrity, and the piety of the person exercising the right. Only the person concerned or Allah knows whether the right is being exercised to meet a real need or just for sensual pleasure. The law grants natural rights and hedges them round with necessary restraints to check improper use. In the discussion on divorce, you have noticed that a man is given the right to divorce his wife, but at the same time, several checks have been placed on him. He has to forego the dower he gave her. He is not to divorce her during the menstrual course. He should give 3 divorces during 3 periods of cleansing. He should keep her with him during this period of waiting, and when at last the 3 divorces have been pronounced, he should not remarry her unless she has had conjugal relations with and divorced by another husband. In the same way, a woman has been granted the right to get a separation, but some restrictions have also been placed on her. And it is not lawful for you to take any part of what you have given them, unless both spouses fear that they cannot keep within the limits set by Allah. Then if you fear that the spouses cannot keep within the limits of Allah, there is no blame on the 2 of them for what she gives up to become free thereby. 2:229. The following mandates follow from this verse. Aikula demands a situation in which there is a fear that the limits set by Allah may be violated. The words, there is no blame on the 2 of them, suggest that though kula is undesirable like a divorce, when there is a fear that the limits of Allah might be violated, there is no harm in obtaining a kula. 2. If a woman wants to break the marriage tie, she should part with money just as a man has to forego the dower when he chooses to divorce the wife. In case of divorce by the husband, he has to forego all that he has given to the wife. But if the wife wants separation, she is entitled to it on giving back part or all of what she received from the husband. The mere wish of the wife to repudiate the marriage tie by returning what she has been given is not enough for obtaining a kula. The husband too should be willing to accept payment and let the wife go. In other words, the woman cannot part with some money and leave the husband. Separation will be legally effective only when the husband accepts the money she offers and divorces her. Evende, kula becomes final when the woman demands separation on payment of a part or the whole of the dower, and the man accepts the payment and divorces her. The words of the Quranic verse show that kula needs only the mutual agreement of the spouses. This verse contradicts the view of those who feel that kula has to be supported by a decree of the court. Islam does not like dragging into courts things that can be settled at home. In case the wife offers to buy freedom from the marriage life and the husband turns down the offer, she has the right to go to court. The words of the verse, Then, if you fear that the spouses cannot keep within the limits of Allah, clearly indicate that the word you refers to the men of authority among Muslims. It is their foremost duty to protect the limits set by Allah. They are duty bound to look into the woman's case, and if they are convinced that there is the fear of Allah's limits being violated, they ought to let her exercise the right she has been granted to respect Allah's limits. These brief mandates give no details of the circumstances which amount to the fear of overstepping Allah's limits. Nor is there any hint as to what should be the reasonable amount of ransom money or what the judge is to do if the husband refuses to accept a reasonable amount being offered. However, these details can be ascertained from the Kula cases brought to the Holy Prophet, peace be on him, and to the four caliphs who succeeded him. Kula precedents from early history. The most well-known Kula case is the one in which the wives of Thabit bin Qais got separation from him. Fragments of this case lie scattered in the books on Hadith. Pieced together, these fragments shed a good deal of light on the various aspects of Kula. Thabit had two wives. One of them was Jamila, the sister of the infamous hypocritical leader Abdullah bin Ubayy. Jamila did not like the looks of Thabit. She approached the Holy Prophet, peace be on him, with a Kula petition. She said, "Messenger of Allah, nothing can keep the two of us together. As I lifted my veil, I saw him coming. Accompanied by some men, I could see that he was the blackest, the shortest, and the ugliest of them all. By Allah, I do not dislike him for any blemish in his faith or his morals. It is his ugliness that I dislike. Had the fear of Allah not stood in my way, I must have spat on him when he came to me. Messenger of Allah, you can see how good-looking I am. But Thabit is an ugly man. I find no fault in his faith or his morals. But I am afraid my desperation might drive my Islam closer to disbelief." 3. In reply to her petition, the Holy Prophet, peace be on him, asked, "Will you give back to him the garden he gave you?" Her reply was, "Certainly, O Messenger of Allah, I am prepared to give even more." "No, nothing more. Only give him back his garden," said the Messenger of Allah. He summoned Thabit and told him to accept the garden and divorce the woman. Thabit's second wife was Habiba. Her story has been narrated by Imam Malik and Abu Dawud as under. One morning, as the Holy Prophet, peace be on him, stepped out of his house, he found Habiba standing by the door. He asked her what she wanted. She burst out, "Messenger of Allah, Thabit and I cannot pull on together." Thabit was summoned. Habiba repeated her petition. "Messenger of Allah, I have with me all that Thabit gave me." The Holy Prophet, peace be on him, told Thabit to take back what he had given and to divorce the woman. Reporting from the Hazrat Aisha, Abu Dawud and Ibn Jarir state that Thabit had given Habiba a severe beating, breaking a bone. She complained to the Holy Prophet, peace be on him, who told Thabit to take back part of what he had given to Habiba and divorce her. However, Habiba's words, as reported by Ibn Majah, show that Habiba said nothing about the beating. Her only complaint was about the man's ugly looks, and she too expressed her disgust, declaring that but for Allah's fear, she must have spat on Thabit's face. In another case, a man and wife were brought before Caliph Omar. The woman pleaded for Kula. Omar counseled her to patch up and try to pull on with the man. She was adamant. Omar ordered that she be kept alone in a cell for 3 days. On the 4th day, she was produced before him. Asked how she felt, she declared on oath that those were the 3 nights of peace she had known in years. Omar was moved by the depth of her misery. Summoning the husband, he delivered his judgment, grant her separation, even though it be in return for her earrings. Rubaya, daughter of Muawiz, sought separation from her husband in return for all her property. The husband did not accept the deal. The case was brought to Caliph Osman, who accepted the woman's plea and allowed the husband to take, in return for separation, all that belonged to the woman, even her head covering. Mandates concerning Kula, the above quoted precedents, highlight the following points. I. The complaints made by the 2 wives of Thabit bin Qais provide an illuminating commentary on the Quranic verse. So if you fear that the 2 spouses will not be able to keep with the limits of Allah. The ugliness of the husband was considered by the Holy Prophet, peace be on him, a sufficient cause for Kula. No comments were made by the Holy Prophet, peace be on him. He had his eye on the objectives of the Sharia. Feeling convinced that the women had deep dislike for the man, he decreed their separation, knowing full well that keeping them tied to the man will only add to their bitter hatred and could lead to far more undesirable results, both morally and culturally, than Kula. Such results could deal a death blow to the objectives of the Sharia. The clear deduction from this precedent is that for enforcing the decree of Kula, all that is needed is the proved evidence of the woman's deep dislike for the husband and her refusal to live with him. But the precedent set by Caliph Omar shows that the judge can take suitable steps to establish, without a shadow of doubt, the woman's hatred and dislike for the husband, so he can be sure that there is little hope left for the couple to pull on together. Omar's action also shows that it is enough for the judge to gauge the intensity of a woman's hatred and disgust. He need not dig into the causes that generated hatred and dislike. It is reasonable to presume that a woman can dislike her husband for reasons she cannot disclose to others. Maybe she dislikes him on grounds that may appear insufficient to others, but which are unbearable for her because of their cumulative effect. So the only business of a judge is to make sure that the woman bears hatred towards the man. It is none of his business to weigh the reasons she is giving and to see whether or not they are sufficient to generate hatred. The judge is free to counsel the woman and persuade her to pull on with the husband, but he cannot force her against her will to do so. Khula is a right granted to her by Allah. If she expresses the fear that she will not to be able to keep within the limits of Allah, in case she stays tied to the man, no one has the right to tell her that she must pull on with the man, no matter what happens to the limits of Allah. In Khula cases, the judge does not have to find out whether the woman's request for separation is based on a genuine need or whether it is actuated by sex hunger. That explains why the Holy Prophet, peace be on him, and the caliphs did not touch upon that point when dealing with Khula cases. As a matter of fact, a thorough probe into this problem is beyond the power of a judge. Moreover, the woman has been granted the right of Khula to match the man's right to divorce. In both cases, the likelihood of sex hunger is there, but the man's right to divorce is not postulated on the condition that it shall not be used for sex hunger. So as a legal right, Khula should also be free from all restraints. The third point to be borne in mind is that a woman may demand separation either on genuine grounds or just for sex hunger. In the first case, it will be unjust to turn down her demand. In the second case, the refusal to grant khula will destroy the important objectives of the Sharia. A woman who is sex hungry by temperament is sure to devise ways for the satisfaction of her passions. Finding the rightful ways blocked, she will resort to illegal ways, which will certainly be worse. A woman who marries 50 husbands, one after another, is better than the one who marries only one husband but commits a single fornication. If a woman makes a demand for khula and the husband turns it down, the judge would tell him to let her go. All precedents show that in such cases the Holy Prophet, peace be on him, and the caliphs ordered the man to accept money and leave the woman. In any case, the decree of the judge is binding on the parties seeking legal help. In case of default, the judge can put the defaulters in jail. In the Sharia, the role of the judge is not that of an advisor. His decree is not an advice to be accepted at will. Relegated to such a position, the court becomes meaningless for the people. The separation resulting from khula, as explained by the Holy Prophet, peace be on him, amounts to an irrevocable divorce. It takes away from the husband, once for all, the right to revive marital relations. The survival of this right obviously nullifies the very purpose of the law, khula. Moreover, the payment made by the woman to the man is the price paid for freedom from the bond of marriage. In case she is denied this freedom after making the payment, it will amount to cheating on the husband's part, which the Sharia cannot allow. However, if the woman wants to remarry the man, she can do so, but only after she has had marital relations with another man and has been divorced by him. No limit has been set by Allah on the amount to be paid as the price of khula. It is up to the spouses to agree upon any price. However, the Holy Prophet, peace be on him, did not approve of anything beyond the dower given by the husband. His view on this point was, the man granting khula should not take from the woman more than what he has given her. Ali too considered it undesirable that a price higher than the dower should be demanded. This view has received the support of all leading jurists. It has even been suggested that if it is the cruelty of the husband which is goading the woman to demand khula, it is undesirable that the man should receive anything. The Standard Handbook of Sharia Law, Hidayah, states, if separation is the result of his ill treatment, it is undesirable that he should receive from her a price. These comments and observations lead to an obvious conclusion, viz. If a woman demanding khula can prove her husband's cruelty or can show other reasonable grounds for khula, she should be granted khula on giving back half the dower or even less. However, if she cannot prove either of the two things, she should be called upon to return the whole of the dower or the greater part of it. In case the woman's behavior betrays sex hunger, the judge can punish her by making her pay more than the dower. Basic errors about khula. The discussion of khula has made it clear that Islamic law maintains a balance between the rights of the man and woman. It is an error on our part that we have, in actual practice, deprived women of the right of khula. Contrary to the principles of the Sharia, we have left khula to the will of the husband. This has led to, and is still evident in the denial of justice to women, for which the law promulgated by Allah and His Messenger is not to blame. If this right of women can be rehabilitated even today, many of the problems plaguing our marital affairs will be solved. In fact, most of them will not arise at all. The element that has practically robbed women of the right of khula is the mistaken belief that the lawgiver has left khula entirely to the spouses and the court has nothing to do with it. The result is that it is only up to the man to grant or deny the woman a khula. If the woman wants khula and the husband, out of selfishness or sheer mischief, does not grant this, the woman is left with no option and solution. This situation is contrary to the intention of the lawgiver. The lawgiver had no intention whatsoever to make one of the parties to the marriage bond helpless and place all powers in the hands of the other party. Had it been so, the lofty moral and cultural objectives associated with marriage would have been meaningless. It has already been explained that the Islamic Sharia bases the marital bond on the principle that as long as this bond can be maintained with moral purity, love, and compassion, it is laudable and imperative to strengthen it and reprehensible to break it or have it broken. When this bond becomes a source of moral transgression for both or one of the spouses, or in place of love and compassion, it gets permeated with hatred and disgust. Its dissolution becomes necessary, and its continuance runs counter to the objective of the Sharia. To serve this basic principle, the Sharia has equipped both parties to the marriage bond with a tool with which they can solve their problems in case the marriage tie becomes unbearable. The tool given to the husband is the divorce, which he is free to use, and the woman is equipped with the legal tool known as khula. The procedure laid down for the use of this tool is that in case she wants to do away with the marriage bond, she must first put the demand before the husband. If he turns it down, she must have recourse to the court. That is how a balance, enjoined by Allah and His Messenger, can be maintained between the rights of husband and wife. But this balance was upset by doing away with the powers of the court. The elimination of the court made the legal tool given to the woman worthless. In actual practice, the law got corrupted to mean that in case the marriage bond gives man the fear of breaking Allah's limits, or it becomes unbearable for him, he can snap it off. But if a similar fear grips the wife or marital life becomes unbearable for her, she has no way of doing away with the marriage bond. So long as the husband himself does not let her go, she is obliged to remain tied down anyway, though it may be impossible for her to keep within Allah's limits, and the lofty objectives of the marriage bond may go to the winds. Does anyone have the courage to place the blame for such glaring injustice on the law given by Allah and His Messenger? If anyone has the audacity to say so, he shall have to prove on the authority of the Quran and the Sunnah, not on the authority of quotations from jurists, that Allah and His Messenger gave no powers to the court in khula cases. Powers of the court in khula. Read again the verse of the Quran stating the law on khula. If you fear that they, the spouses, will be unable to keep within the limits of Allah, there is no blame on the two of them. If she, the wife, gets separation on payment of ransom. 229. This verse speaks of the spouses in the third person, they. So the pronoun you cannot refer to them. Inevitably, it has to be conceded that it is the people invested with authority by the Muslims who have been addressed. The divine mandate means that in case the spouses cannot arrive at an agreement in a khula case, the matter should be referred to the people of authority. This interpretation of the verse is supported by the khula precedents already quoted. The mere fact that women came to the Holy Prophet, peace be on him, and to the caliphs with khula petitions, and they decided these cases, conclusively proves that in case of disagreement between the spouses on khula, the wife should have recourse to the law. If the judge can only hear such cases and has no power to enforce his decisions on an unwilling husband, recourse to the court will be an exercise in futility. Do the traditions prove that the judge has no power in khula cases? Khula cases decided by the Holy Prophet, peace be on him, and his caliphs quote commands like divorce her, get separated from her, let her go, or as the reports say, he ordered the man to. The report from Ibn Abbas, quoted by Ibn Jurayr, is he separated the two of them. The same words have been used in the reports from Jamila herself, the woman who got khula. These facts leave no room for doubt about the court's powers in khula cases. Now, can a judge impose his decision on the husband who may look upon the court's decision just as an advice and may ignore it? We come across no such precedent in the time of the Holy Prophet or in the time of the caliphs who succeeded him. Of course, Ali did have to tell a headstrong husband, you shall not be let off unless you accept the verdict of the two arbiters as your wife has done. If Ali, as judge, could put a husband in prison for not complying with the verdict of the two arbiters, he would certainly have jailed him if he had ignored his verdict. Moreover, there is no sense in depriving the court in khula cases of powers which it normally exercises in other cases. In books on law cases, one comes across situations where the judge is given the powers to separate the spouses in case the husband ignores his verdict to divorce the woman. Then why should the judge not have this power in khula cases? In the pages that follow, we will look at the remedial measures prescribed by noted jurists in case the husband turns out to be impotent, eunuch, leper, or feeble-minded. In a like manner, fresh ground has been broken in the form of legal clauses giving the spouses married in infancy the option to retain or dissolve the marriage tie. In this background, it becomes all the more necessary that in granting khula to the woman, the court should be given full powers. Unless this is done, the helpless women who are refused khula would either resign themselves to lifelong misery or would be driven to commit suicide. The other alternatives before them are to satisfy their natural passions through sin or to get rid of the marriage bond through apostasy. An example will make the point clear. In case of the husband's impotency, the verdict of the jurists is that the man should be given a year's time limit for medical treatment. After the treatment, if he is able to have even a single sexual intercourse, the woman loses her right to get the marriage dissolved, even though the intercourse may not have been to her full satisfaction. If the woman was aware of the man's impotency at the time of marriage and still gave her consent to be tied to him by marriage, she is debarred from seeking a legal remedy. If she had even a single intercourse with the husband after marriage and then he turned impotent, she loses her right to go to the court. In case the woman learns about the husband's impotency after marriage and still agrees to live with him, she gets debarred from getting the marriage dissolved. In these cases, the woman stands debarred from demanding the dissolution of the marriage bond. The only legal course for her to get rid of the worthless husband is to demand khula, but unfortunately she finds this door also closed. The husband is not willing to leave her even if she is ready to pay him more than the dower he had given. She seeks help from the court, but is told that it is not empowered to force the man to divorce her or to separate the two of them by a decree. Just contemplate the fate of this luckless woman. The options before her are suicide or the killing of her passions like a Christian nun by undergoing soul-chilling privations in secluded life. The two other options are a life of sin within the bonds of marriage life or bidding farewell to Islam. But is this the intention of the Islamic law to confront women with options like these? Can marital relations of this type achieve the objectives which inspire the Islamic marital law? Can such spouses have love and compassion for each other? Can they render any service to society? Can the angels of happiness and bliss ever step into their home? Can such a bond of marriage have the remotest claim to be called a shield against sin? Can it hope to defend faith, morality, and chastity? If the answer is no, then who is to blame for ruining the life of an innocent woman, driving her into a life of sin, or goading her out of the pale of Islam? Surely Allah and His Messenger are not to blame because there are no blemishes in the law they gave. The Sharia Tribunal. The foregoing discussion on divorce and khula makes it clear that Islamic marital law is based on the postulate that the marriage bond, as long as it endures, should be a symbol of respect for the limits of Allah and for mutual love and compassion. The Quran calls this the retention of the tie in the proper way, if such a union becomes impossible. The spouses should separate in a nice manner. In other words, the spouses either live together in harmony or separate in kindness. Their differences should never be allowed to develop into situations which embitter their lives, trigger disputes among families, spread indecencies in society, encourage immorality, and hand down evil traditions to the coming generations. It is to forestall these evils that Islam has given man the right to divorce. The woman has been given the right to demand separation so that she may, if she wants, act upon the Quranic mandate of separating in peace. Me. References. 1. The best thing is not to pronounce the third divorce, but to let the third period pass by. That will leave the possibility of remarriage between the spouses if they so desire. But with the pronouncement of the third divorce, the separation becomes irrevocable. The two of them cannot become spouses again until the woman marries another man and he divorces her in the same manner. The sad thing is that most people are unaware of this legal point. When a man wants to divorce, he hastily pronounces 3 divorces at a time. Most of them later regret and run after jurists for advice. 2. The point has already been emphasized that the intention of the Islamic law is to protect the marriage tie. Once a man and woman have been tied together by marriage, the bond should stay as long as possible. It can be dissolved only when all possibilities of their relationship have been fully explored. That is why the law wants that one should decide on divorce only after long and careful consideration. Even after the first pronouncement of divorce, the door for reconciliation should be kept open for 3 menstrual courses. A man making 3 simultaneous pronouncements of divorce throws to the winds all these considerations so essential for the Islamic law. 3. Fear of Islam being driven closer to disbelief means that if despite her deep dislike and disgust she kept herself tied down to Tabit, she was afraid she might fall short of some of her duties as wife, laid down by Allah and His Messenger. As a true believer, she looked upon this shortcoming as disbelief. Compare this with the thinking of some of the Maulvis of today. They insist on regarding a person a believer even though he discards daily prayers, fasting, payment of zakat, the Hajj, and openly indulges in gross indecencies. They assure such people of the heavenly bliss and condemn their critics as Kharijiites. 4. It should be clearly understood that the Islamic law does not like family disputes reaching the court in full public gaze. That is why it has provided legal remedy for both the spouses so they may, as far as possible, settle their disputes at home. Recourse to the court is in the last resort, when settlement at home becomes impossible. However, some people are quarrelsome by temperament. They can neither live together in harmony nor can be persuaded to part decently. Moreover, problems arise in conjugal relations where differences arise between spouses regarding their rights. They find it impossible to live together in peace or to separate in peace. That is why the Sharia has provided, in addition to divorce and khula, a third remedy for settling mutual rights and for protecting the limits of Allah, and that is the Sharia Tribunal. 5. Fundamental issues about the Sharia. Before taking up the issues relating to the Sharia Tribunal, some fundamental points need to be clarified. The first condition for the court. The first condition for the Sharia Tribunal is that it has to be an Islamic court. The judge must be a Muslim. The first reason for this has been clearly stated by jurists in matters relating to Islamic Sharia. The decree of a non-Muslim may apparently be enforced on Muslims, but in reality it does not get enforced. For example, if a non-Muslim officer dissolves the marriage of a Muslim couple, it does not get dissolved, even though the verdict be in conformity with the law of Sharia, and even though the spouses have been practically separated. In reality, the marriage tie stands intact, and the woman is not free to marry another man. If she marries, the marriage will be nullified in the eyes of the Sharia. Children born of this marriage will be illegitimate. The second reason is that, on grounds of principle, the Quran does not accept the verdicts of a non-Muslim court. In the affairs of Muslims, in particular, its definite stand is that Allah does not approve of non-Muslim courts' decisions on Muslim issues. I have fully discussed this issue in an article under the heading A Very Important Query, which appears as an appendix at the end of the book. Independent thinking is essential. There are always problems, the solution of which is left to the judgment of the court. It is true that the Sharia contains detailed law, but in personal dealings, the particular circumstances of each case have to be kept in mind for interpreting and enforcing the law. Moreover, suitable corollaries have to be drawn, and the spirit of the law has to be maintained, while conforming to the conditions given in the chapter on disputes. These functions cannot be discharged unless the judge is capable of independent thinking and possesses, at the same time, a deep faith in and respect for the law he has to enforce. Obviously, these qualities can only be possessed by a judge who is a Muslim by faith, has a full grasp of the Islamic law and its all aspects, fully understands the spirit of this law, is conversant with the sources of this law, and has intimate knowledge of the structure of the Muslim society. A non-Muslim judge can never combine all these traits, so it cannot be hoped that he can deliver a sound judgment in cases of Muslim personal law. Harm done in India by the absence of Sharia bench. Even after the establishment of the British rule in India, affairs involving the personal law of the Muslims were, till 1864, settled by Muslim qazis who were selected, and, like common civil suits, cases involving Muslim personal law were also handed over to the civil courts established by the British. The first harm resulting from this was that the issues falling under Muslim personal law, according to the principles of the Sharia, were nearly wiped out. It became impossible for the Muslims to get from the courts a verdict in Sharia cases which could be looked upon as a legitimate verdict from the point of view of their religion. The second harm, which is in no way less injurious than the first one, was that the office of these courts neither had the means to develop an insight into the principles and branches of the Muslim law, broad enough to ensure independent thinking, nor did they possess a respect for this law that could stop them from overstepping its limits. Their knowledge was drawn from books written by authors like Hamilton, who did not know Arabic. He translated Hidayah with the help of a Persian book. He was simply incapable of understanding Hidayah. He committed so many blunders in translating the common technical terms of Muslim jurisprudence that one has to refer to Hidayah again and again to understand Hamilton. In the same way, Bali's Digest of Muhammadan Law consists of the translation of portions from Fatwa-e Alamgiri. MacNaughton's book, Principles of Muhammadan Law, is a jumble of defective material, concocted and misconceived notions, distorted facts, and misinterpretations. Some British judges themselves have confessed their lack of knowledge. Justice Markby remarks in one of his judgments, "The means at the disposal of the court for understanding Muslim law are so meager and narrow that I am gladly willing to adopt every device to avoid deciding cases involving this law." With such limited knowledge on their part, these courts have the audacity to set new precedents in Islamic law, and going beyond its limits without hesitation, because their faith requires no respect for this law, nor does the judicial system of the ruling power place any restrictions on them to keep within the limits of the Islamic law. The following remarks of Chief Justice Garth, occurring in the judgment of a case, are enough to underscore the position of these courts. Islamic law, to which our attention has been drawn, exists in ancient books. It was enforced centuries ago in Baghdad and other Muslim countries where the legal and cultural background was very different from that of India. In deciding disputes arising among Muslims, we try, as far as possible, to follow Islamic law. But in the first place, it is very difficult to find out the mandates of this law. It is still more difficult to reconcile differences in the views of the top jurists like Imam Abu Hanifa and his pupils. So we should try, as far as possible, to find out the right principles on which a decree is to be based. Then we should enforce it, keeping in mind the requirements of justice, goodwill, and the legal and cultural background of the country. These remarks clearly show that a judicial officer who concedes his ignorance of the Islamic law and declares his inability to reconcile the conflicting views of the top jurists openly considers it right that despite his defective knowledge of the Islamic law, he should set new precedents. In one of his decisions, he unhesitatingly declares that in the enforcement of Islamic law among Muslims, he is not bound to keep himself within the limits of this law. He has also to keep in mind the legal and cultural background of the country, the principles of justice, as well as his own convictions. The so-called Muhammadan law being enforced by the courts of this country is the product of this independent thinking, which is rooted neither in faith nor in knowledge. Even this defective law is not rightly applied to our Sharia cases, and the situation is deteriorating day by day. The first step towards reform. The minimum workable arrangement at present for reaching correct decisions of cases involving marriage, divorce, and other Sharia matters is that the Muslims should have their cultural autonomy. They should be empowered to set up their Sharia courts where pious religious scholars should be appointed as judges. They should be men of insight and deep knowledge in Islamic law. This need has to be met if it is going to be made for Muslims to lead their lives as Muslims in this country. In case they cannot be granted this right, the minimum which can be perforce accepted as a last resort is that in each district there should be a council of 3 Muslims commanding the confidence of the Muslims of the district. The council should have at least one acknowledged religious scholar, and it should decide cases in accordance with the Maliki Code of Law. The government should then be pressed to concede that in matters of Muslim marriage and divorce, the decisions of the council will have the force of the court decisions, and no appeal against them shall lie in any other court. Cases of Muslim marriage and divorce that come to law courts should also be transferred to the councils. Besides British India, in the Indian states too, both Muslim and non-Muslim, the setting up of these councils should be the first step towards reform. Following the examples of the British government, even some states have abolished the courts of qazis and replaced them with common civil courts, which have been empowered to hear even Sharia cases. These states must either revive the qazis or should set up Sharia councils. Unless this legal structure is provided, it will be useless to present in the legislatures a bill for the enforcement of Islamic law and get it passed. Need for a modern legal code. In addition to the arrangements for Sharia courts, what is also needed is the compilation of a manual containing mandates concerning the Sharia affairs of the Muslims. The mandates should be in the form of clauses with explanations. The manual should replace the so-called Muhammadan law in the Sharia courts and councils. When mixed courts were set up in Egypt, need for such a code was felt, which could put together the necessary laws from authoritative sources. At the instance of the Egyptian government, a committee of scholars from the Al-Azhar University, under the chairmanship of Qadri Pasha, accomplished this work. The code compiled by the committee was approved by the Egyptian government and was introduced into the courts. In India too, there is need for the appointment of such a committee. It should consist of selected religious scholars from each school of thought and some law experts. They should compile a detailed code with annotations. Its manuscript should first be circulated among the ulama of various schools of thoughts and then be revised in the light of their reactions to it. On finalization, it should be declared to be the standard compendium of Sharia law in the light of which the Sharia affairs are to be settled in future. The so-called Muhammadan law, resulting from the precedents set by British judges or judges devoid of knowledge and faith, should be declared as void. It may be asked as to why a new code be compiled when our books on jurisprudence have discussed all problems in detail. This is not just a possibility, but a certainty that a section of people, because of their peculiar mentality, will oppose the suggestions. So, we briefly state reasons which, in our opinion, make this task essential. A cursory glance through the old books on jurisprudence will convince anyone that various problems have been discussed at random in an outmoded style and sequence. They are couched in a language so obtuse and obsolete that the fine shades of its technicalities are often beyond the grasp of even those who teach these books. But now, the book publishing system is easier and more comprehensive. In such books, the laws are discussed clause by clause. Under each clause, one finds the explanation of important terms, clarification of objectives, details of the corollaries that follow it, precedents set by notable judges, and interpretations by various experts. Moreover, the list of contents and indices facilitate the location of issues. No sensible man will deny that the compilation of modern books on Islamic jurisprudence must benefit from the advances made in the art of compilation and clarification as a result of continuous human endeavor. After all, the ancient style of compilation was not based on the divine command or the mandate of the Islamic law. It is not obligatory to adhere to it, nor is it sinful to depart from it. A more important reason than this is the fact that the mandates discussed in the old books on Islamic jurisprudence are predicated on general human situations. It is wrong to apply them offhand, word for word in every case. The right application depends on the following considerations: the moral, cultural, social, and economic conditions of the Islamic society in which the law is going to be enforced must be kept in mind. Their national habits, characteristics, and customs, as well as their environments and the effects of the environments, should also be taken note of. We need also to note how strong or weak is the influence of Islam on their nature and their affairs, and to what extent their Islamic characteristics have been changed by foreign influences, and as a result of general cultural conditions, what changes have occurred in the legal aspect of their affairs. Secondly, the individual circumstances of each particular case need scrutiny. The personalities of the parties, their ages, education, physical health, their economic and social status, their previous history, family traditions, the general condition of the group to which they belong are the factors that have to be weighed before forming an opinion as to how the law should be applied to them in a particular aspect of the matter, so that the objective of law is realized and the principle of the law is established. If someone finds an old book on Islamic jurisprudence and tracks down the corollary of a law, then by blindly following the considerations listed above, he starts applying this corollary to each case that falls under it. He will be like a physician who has got the prescription of any illustrious Greek physician, but he deals with the prescription without taking into account the climate, the weather, the temperaments of the patients, and the different stages of the disease. The medication prescribed by ancient physicians may be absolutely right and sound, but it was not meant to be handled by quacks. Its proper use requires knowledge, experience, intelligence, and common sense. In the same manner, the corollaries deduced by our great thinkers from the principles of Sharia and from the basic mandates are absolutely correct, but those great men could never have imagined that the results to their reflective thought were going to be used without comprehension and reasoning, just as an ignorant post office person goes on mechanically stamping each letter with the same seal. Islamic law was framed with such consummate wisdom that it was almost impossible for a man or a woman governed by this law to fall a prey to immorality and become a source of corruption for society. It was just impossible that the law should cause hardship that forces a man or a woman to flee out of the pale of Islam. But we witness today not only endless domestic disputes, but also moral turpitude and even apostasy among Muslims, only because in most cases people find it impossible to get a correct, just decision under the Islamic law. Unfortunately, the muftis as well as the judicial officers equally lack insight and reflective thinking. They care little for the country, the society, and the nature of the particular case in which a general mandate is being enforced, although the principle of Sharia demands that a general mandate needs to be particularized according to the nature of the aforesaid factors. The Islamic law emphasizes this point so that none of its principles is overlooked. As for the government officials, their handicap is self-evident. As for the religious scholars, all that they are capable of is to locate and quote various rulings from old books on Muslim jurisprudence exactly as they find them written. Some of them have been granted by Allah breadth of vision and insight into the faith, but not a single one of them has the courage to examine critically an old corollary and alter even a word of it. This is because they are afraid of making an error on the one hand. There is the fear of being dubbed an innovator by the other ulama on the other. The only solution to this problem is that outstanding and influential ulama of each state should jointly address themselves to the task and should compile a code for Sharia affairs suiting to the existing moral, cultural, and economic conditions of the Indian Muslims. The code should be flexible enough to make necessary changes in its sub-clauses to suit the particular features of individual cases. If someone brands this course of action as innovation, we must explain to him that he is in error. He should be made to see the difference between following the great leaders of thought and following the prophets. He does not understand the meaning of following a particular school of Islamic jurisprudence. To him, following a particular school means to elevate this school to the status of faith, to raise its founder to the position of a prophet, and to regard his rulings immutable like the verses of the Quran. To him, it is an article of faith that the rulings of his school of jurisprudence need no correction, modification, or addition, and it is a serious sin to subject them to research or criticism. It is his belief that it was permissible till the 4th century AH to feel free, while deciding cases, to ignore a corollary from another school of jurisprudence, but such course of action stands debarred now. Such blind following cannot be traced among the scholars of the past, nor is there any proof of it in the Sharia. The pupils of Imam Azam differed with their master on hundreds of problems, and still they remained his followers. The later-day scholars of Hanafi jurisprudence made their choice from the conflicting views of Imam Azam and his pupils, preferring one view and rejecting the others, and basing their verdicts on the view of their choice. Despite this research and criticism, no one can accuse them of innovation. From the 4th century of Hijrah to the 8th and 9th century, the Hanafi ulama constantly amended, according to the needs of their times, the corollaries and precedents of the ancient scholars. Their independent judgment was never regarded as innovation. No one has the courage to declare that Hanafi jurists like Abul Layth Samarkandi, the great Imam Sarkasi, the author of Hidayah, Qazi Khan, the author of Kanz, Allama Shami, and other scholars of their standing were innovators, just because they introduced flexibility into Hanafi jurisprudence. To cope with the circumstances and needs of their times, they based their verdict on the laws of other schools of jurisprudence. If they found the Hanafi jurisprudence harmful or impracticable, they made it a clause of Hanafi legal system that in case of need, it is permissible to base a verdict according to other schools of jurisprudence, provided this step is not taken for selfish ends. It is true that if the people were free to follow other school of jurisprudence just to suit their needs, or if they took undue advantage of the concessions allowed by their own jurisprudence, there is the danger of using the law for selfish ends. Each school has allowed concessions from its own point of view to cope with special situations. If these concessions are exploited for personal gain, religion becomes a mockery and social life becomes chaotic. But if this step is taken by pious scholars of religion in good faith and by mutual consultation to meet the current needs of Muslims, there is no fear of any harm, materially or spiritually. Even if these people unwittingly commit a mistake, the Quran declares them free from blame and worthy of divine reward. The greatest hazard in this way is that a section of ulama will start opposing it vehemently, and their followers will develop ill will against its pioneers. But a greater danger lies in avoiding this course of action. Hard pressed by their needs, Muslims will ignore Islamic law and will start following their carnal lusts. Religion will become a mockery, and Allah's limits will be openly infringed, leading to the spread in an epidemic form of moral turpitude, disbelief, and sin. Like Christian nations, Muslims too will reject their religious code and adopt man-made laws. On the day of judgment, the religious leaders of these sinners will also be answerable to Allah, the Almighty. He will ask them, "Did we bless you with knowledge and wisdom that these gifts should not be used? Were you given the book and the sunnah of our Prophet that you should keep sitting over them and the Muslims should become lost in the darkness? We made the faith easy. What right did you have to complicate it? We commanded you to follow the Quran and Muhammad, peace be on him, who made it obligatory on you to place your forefathers above them. Our Quran embodied the solutions to all problems. Who told you not to touch the Quran and consider books written by men enough for yourselves? It is too much to hope that in the face of this interrogation, books like Kanzud Daqaiq, Hidayah, and Alamgiri will be of any value to a religious scholar. All these issues are necessary and important. Their detailed discussion being inevitable, this much space had to be given to them. We will now turn to the real topic of our discussion, references. 1. I want to re-emphasize the point that I do not believe in true worth of the Sharia bench set up by the orders of a non-Muslim government, but I am discussing here the minimum feasibility of a procedure by which, till such time when an Islamic government is established, affairs involving the personal law of the Indian Muslims can at least be straightened out. 2. According to the Hanafis, the verdicts of these councils cannot be a substitute of the judgment of the Qazi, but in case the councils are granted the power to enforce their verdicts and their powers do not end just at the hearing of cases as arbiters, but extend to the authority of enforcement, then even for the Hanafis, their verdicts will be as good as the verdicts of the Qazis. 3. The code was rendered into French under the name Droit Musulman. Besides Egypt, it is also used in the court of other Muslim countries. 6. Fundamental instructions. Since the Holy Quran is a book dealing with all the fundamentals and principles of life, secondary problems relating to marital relations have not been discussed by it in detail. However, some broad principles have been stated which encompass almost all secondary problems and offer the best guidance for deducing corollaries. So before taking a look at the details of the law, it is necessary to understand fully the principles and rules laid down by the Quran. Consider the following verses. 1. Do not marry idolatresses until they believe in Islam. 2. 221. 2. Do not give believing women in marriage to idolaters until they believe in Islam. 2. 221. 3. Lawful for you are the chaste women from among those who have been given the book. 5. 5. 4. Do not marry idolatresses. Do not give your women in marriage to idolaters. 2. 221. These verses state the rule that a Muslim male cannot marry an idolatress. However, chaste women from among those who have been given the book are lawful for him. But a Muslim woman can neither marry an idolater nor a man from among those who have been given the book. These verses also lay down the rules that a man is free to seek the hand of a woman, but a woman is not absolutely free in this matter. To give her in marriage to someone is the business of her guardians. True, there is the ruling of the Holy Prophet, peace be on him, that a woman's consent is necessary for marriage to a man, and no one has the right to give her in marriage against her will. But a woman's marriage is closely related to family interests, since the Quran wants that a woman's choice alone should not settle the affair. Her guardians must also have a say in the matter. In return for the benefit you draw from them, give them their dower as an obligation. 4. 24. And how will you take back the dower you gave them after you have enjoyed each other's companionship? 4. 21. And if you divorce them before you touch them, and the dower has been settled, you shall have to pay half of what has been settled. 2. 2:37. These verses show that dower is in return for the benefit a man draws in the form of sexual intercourse, so it becomes payable after the first intercourse and cannot be nullified. Of course, the wife may, of her own free will, remit the whole or part of it. She may also give it up in return for kula. If you have given any one of them a lot of money, do not take back anything from it. 4:20. This verse indicates that Islamic Sharia places no limit on dower. No other law can place a limit on it. Men are the guardians for women. It is so because Allah has given them superiority over women and because they spend their money on them. 4:34. This verse makes living expenses the right of the wife. This money is in return for the conjugal rights the man has on her. This right of hers can in no case be nullified unless she herself gives it up or she is guilty of desertion. And let him who has abundance spend out of his abundance, and whoever has limited means, let him spend out of what Allah has given him. 65:7. This verse lays down the rule for the assessment of living expenses. The financial position of the husband is to determine the amount of living expenses. A wealthy man will pay according to his means, and a poor man according to his means. As for the women on whose part you fear rebellious behavior, counsel them and leave them alone in their beds. Then give them a beating. So, if they obey you, do not find excuses to be unjust to them. 4:34. This verse gives the husband the right to punish the wife in case she starts disobeying him and rebelling against him. Even in this case, only two forms of punishment have been permitted. The first one is to cut off sexual relation. The second one is light physical beating, which is permissible only in cases of outrageous misbehavior. If punishment exceeds limits, e.g., beating without outrageous behavior, or beating badly for moderate misbehavior, or going beyond light punishment, even for outrageous behavior, it will amount to cruelty on the part of the husband. And if you fear a breach between the two spouses, appoint an arbiter from his people and an arbiter from her people. If they both want improvement in relations, Allah will bring about harmony between them. 4:35. This verse lays down the rule that in case of a dispute between the spouses and their inability to arrive at a mutual compromise, let two arbiters be appointed, one to represent the man and the other one to represent the woman. The two of them should join hands and settle the dispute amicably. The verse is addressed to people of authority among the Muslims. It is they who are to appoint the arbiters. And if the dispute cannot be settled by the arbiters, it is the responsibility of the authorities as a last resort to settle the dispute. Then if you fear that the two spouses will fail to keep within the limits of Allah, there is no blame on the two of them if the woman gets separation in return for ransom. 2:229. The verse cautions the judge that in deciding marital disputes, the crucial factor to guide him should be to see if both of them will be able to keep within the limits of Allah, relating to the discharge of conjugal duties. If the probability is that these limits are going to be violated, then nothing can justify their union. The most important thing is the strict adherence to the limits set by Allah. No price is too high for the discharge of this duty. In the words of the Quran, and whoso goes beyond the limits of Allah, he indeed wrongs his own soul. 65. 1. And do not retain them just to torment them, so that you do them injustice. 2:237. This verse warns men not to make the marriage tie a means of tormenting women and depriving them of their legitimate rights. The Islamic law wants the spouses to share a happy life. As long as a woman is retained, she must be retained in kindness, and if the union becomes impossible to remain intact, and there is the fear of torment or injustice for the wife, separation becomes essential, but it should come about in a decent manner. Islamic law abhors harm and permits no one to harm another person, and do not incline with total inclination to one wife, leaving the other one in suspense. 4:129. This verse lays down the general rule that a man with more than one wife should treat all wives equally. It will amount to injustice on his part if he totally disinclines from one of them. Depriving her of his own company and debarring her from marrying someone else is a veritable torment for the poor woman. Those who swear not to touch their wives, the prescribed limit for them is 4 months. 2:226. This verse specifies maximum limit to which a woman can be left alone in bed. She can stand this much period of separation without feeling oppressed and without overstepping the limits of Allah. Beyond this period, there is danger that either one of the aforesaid things might happen. The verse was revealed to meet a particular situation, but it serves as a guide in all similar situations. Those who accuse their wives and have no witnesses except themselves, let the testimony of one of them be 4 testimonies, swearing by Allah that he speaks the truth, and a 5th testimony invoking the curse of Allah if he be a liar. 6:724. This verse deals with the case of a man who accuses his own wife of adultery but has no witnesses. He must declare on oath 4 times that the accusation is true. He shall have to declare on oath the 5th time that Allah's curse may fall on him if the accusation be false. The solemn statement of the husband renders the wife liable to punishment, which can be averted only if she declares 4 times on oath that the accusation is false, and also makes the 5th declaration on oath that the wrath of Allah be upon her if the man has spoken the truth. If both spouses make these solemn declarations, the court has to separate them. Unless they, the women, agree to forego it, dower, or he agrees to forego it in whose hand is the marriage tie. Into 2:237. This verse unequivocally declares that the marriage tie is in the hands of the husband. It is he who can retain it or break it. Wherever the Quran speaks of divorce, it ascribes the act to the man. This is a conclusive proof that it is the husband who has been given full power to divorce the wife or to retain her. No law can be enacted to divest the husband of this power. But in Islam, all powers are subject to the universal condition that they have to be exercised with the fullest regard for fair play and within the limits of Allah. He who violates the limits of Allah wrongs his own souls is the ever-present warning for the husband. In fact, this divine warning overshadows the entire legal system of Islam. The power granted to the husband is no exception to this all-pervading principle. If a woman feels aggrieved, the Quran tells her to refer her case to Allah and His Messenger, i.e., the court of law. If her complaint is proved valid, the court will take away the man's power. as provided by the Islamic law and use it to separate the spouses. A section of jurists argues that the right of divorce granted to the husband by the Quran is absolute and free from all restraint. If the husband is unwilling to divorce, the court has no authority to strip him of the power and use the power itself on his behalf. The Quran, however, does not lend support to this view. According to the Book of Allah, even man's right to life is subject to the will of the Lord of Truth. How can the Quran arm the husband with a power that remains unchallenged, even though it is maliciously used to trample all the rights of the wife and to flagrantly violate the limits of Allah? Divorce must be pronounced twice, and then the woman must either be retained in honor or allowed to depart in kindness. 2:229. And if he divorces her the third time, she is not lawful to him thereafter until she has wedded another husband. 2:230. These verses explain the right mode of divorcing a woman. The three pronouncements of divorce have to be spaced, as described earlier. The first two pronouncements are provisional, leaving the option of mending and resuming conjugal relations. The third pronouncement irrevocably breaks the marriage tie. References. It was on the basis of this principle that Hazrat Omar issued orders that no married soldier should be kept away from home on military duty for more than 4 months. 7. Corollaries. The fundamental principles of the Islamic marital law have been discussed in the previous chapter. Important corollaries following from these principles are now being taken up in the same order. No attempt will be made to encompass all corollaries. Attention is being focused only on the peculiar problems that need the restatement and elucidation of the mandates of the Sharia in the light of the needs and circumstances of present times. 1. Apostasy of one of the spouses. In modern times, apostasy has assumed a special importance. The apostasy of the husband makes no actual problem because there is general agreement on the fact that the bond of marriage cannot tie a Muslim woman to a non-Muslim husband. But difficulty arises when a wife turns an apostate. Mostly women have turned to apostasy and are still turning to it on the pretext of releasing themselves from husbands who are cruel or whom they dislike. In such cases, the courts set up by the British follow the ruling of Imam Abu Hanifa as quoted in Hidayah and other books. The ruling states that the apostasy of either one of the spouses automatically separates the two of them without a divorce. To check the practice of apostasy, the Indian ulama want to follow the ruling of the ulama of Balkh, Samarkand, and some other ulama of Bukhara. Their ruling is that apostasy does not dissolve the marriage tie. The woman remains the wife of the man despite her apostasy. The ruling is based on the fact that apostasy is being resorted to only as a device to get rid of the marriage tie. The only way to counter this trick is to let the marriage tie remain unaffected by apostasy. However, the acceptance of this ruling is going to create problems which have not probably been foreseen by our ulama. The first difficulty is that in the eyes of the law of the land, as well as the Sharia law, a person is a Muslim or non-Muslim on the basis of verbal profession. There is no way of proving that a woman is actually a Muslim at heart, but she is feigning apostasy in order to be separated from her husband. Secondly, if a woman leaves Islam to become a Christian or a Jewess, her marriage tie, according to the Quran, stays intact. But if she accepts the Hindu, Sikh, or the Parsi faith, or some other faith, it will be against the clear mandate of the Quran to retain the marriage tie. Thirdly, how are you going to apply Islamic law to a woman who has left the fold of Islam to embrace another faith? Indian Muslims live under a non-Muslim government which gives equal treatment to the Muslims, the Hindus, and the Sikhs. If a woman goes over to the Sikh faith or the Arya Samaj, how can we expect the government to force the woman against her will to retain the marriage tie that was solemnized under Islamic law when she was a Muslim? These reasons force us to conclude that Indian ulama can draw no benefit from the rulings of the ulama of Balkh and Samarkand. The thing that should engage our attention is what drives married women out of the fold of Islam. It can be stated with certainty that no more than 2 to 4% of the women leave Islam because of a change in their beliefs, and they are driven to apostasy because they find no legal remedy for the oppression and tyranny to which they are subjected by their husbands. The husband may indulge in the worst kind of cruelty, but the wife is unable to get a kula. The husband may be worthless. He may be afflicted with a dangerous or loathsome disease. He may be a slave to wayward habits, but the wife cannot leave him. These factors make the wife hate his very name and might bring about a total breakdown of mutual relations. Despite all this, the wife finds no way of ridding herself of the marriage bond. Or maybe the whereabouts of the husband have not been known for years, which has made life of the wife intolerably miserable. But she can see no way out of this calamity. Circumstances like this force women to step out of the bond of Islam and seek a sanctuary in disbelief. Searching out legal corollaries to block the path of these unfortunate women from falling into disbelief is also not a right remedy. This step would rather drive the women to commit suicide. The right course is that we take a critical look at the Sharia law and amend it in the light of modern needs and circumstances. The legal hurdle that forces our sisters and daughters to forsake Islam and go into disbelief can thus be done away with. The authentic mandates of Allah and His Messenger have not laid down any constraint that may cause harm and injury to anyone, let alone drive anyone to apostasy. This shortcoming exists only in some of the rulings of the jurists. Such rulings can be replaced by other rulings that can effectively check the apostasy of Muslim women. 2. Discretion of adulthood. The Quran lays down the rule that the guardian of a woman must have a say in the matter of her marriage. This mandate, as interpreted by the Messenger of Allah's word and his practice, makes it clear that it does not seek to give the woman no say in deciding this vital affair of her life. On the contrary, the Holy Prophet, peace be on him, made the consent of the woman an indispensable condition of marriage. Collections of hadith compiled by Abu Dawud, Nasa'i, Ibn Majah, and Imam Ahmad report the case of a girl who approached the Messenger of Allah with the complaint that her father had married her against her will. His reply was that she had the option of accepting or rejecting her father's choice. Nasa'i reports the case of Khansa, the daughter of Qadam. She too made the same complaint to the Messenger of Allah and received the same reply. Qutni narrates a report from Hazrat Jabir that the Holy Prophet separated a couple because the girl had been married against her will. Nasa'i also narrates a report from Hazrat Aisha saying, a woman came to the Holy Prophet, peace be on him, complaining that her father had married her to his nephew against her will. He told her that she was free to accept or reject her father's choice. At this, she exclaimed, Messenger of Allah, I accept my father's choice. I just wanted to make it known to other women that their fathers did not have the final say in this matter. Collections of hadith compiled by Muslim, Abu Dawud, Tirmizi, Nasa'i, and Imam Ahmad all quote the rulings of the Holy Prophet, peace be on him, which say that a woman who has already had a husband has a greater right than her guardian to decide about her marriage, but a virgin woman's consent must be obtained. Abu Huraira reports from the Messenger of Allah, a woman who has had a husband before should not be married without her permission, and a virgin should not be married without her consent. 3. Obligatory guardianship. All the precedents cited above show that one of the principles of the Sharia law is that the consent of a woman is an indispensable condition for marriage. The application of this principle poses a question in the marriage of a minor girl who is incapable of giving her consent. Is she going to lose her right to exercise consent if her father has given her away in marriage? The ruling given by the jurists is that if a minor girl is given away in marriage by someone other than the father or the grandfather, she shall have the right, on attaining adulthood, to accept or reject the marriage tie. In case she was given away by her father or grandfather, she shall have no such right, except when the father or grandfather is known for leading a life of immodesty and reckless behavior. The ruling that a minor girl is living under the inexorable will of the father or the grandfather and has no right, on attaining adulthood, to disapprove of the marriage tie solemnized by her father has no support from the Quran or from any hadith. Its only basis is the argument of the jurists that the father and the grandfather can have no ill will against the girl, so the marriage solemnized by them should be binding on her. The ruling given in Hidayah is, they, the spouses married in infancy, have no discretion of approval after attaining adulthood, because they, the father or grandfather, have mature judgment and great affection. So the marriage tie will be binding for their marital relations, as if they had consented to it on attaining adulthood. This view is entirely based on conjecture and lacks the authority of the mandates of Allah and His Messenger. Moreover, it is open to all kinds of objections. 1. A confirmed hadith of the Holy Prophet, peace be on him, states that he married the minor daughter of Hazrat Hamza to Amr bin Abi Salma, and said that she had the discretion to accept or reject the marriage on attaining adulthood. This clearly establishes the right of minor spouses to exercise discretion on attaining adulthood. No comment was made by the Holy Prophet, peace be on him, to the effect that since he was not the girl's father but only her cousin, the marriage was not binding on her. 2. Islam does not give the father or the grandfather a final say in the marriage of a woman. The final say belongs to woman herself. She cannot be married to anyone without her free consent. It is really surprising that a minor girl should be deprived of this precious right. A woman has been given the right to assert her discretion because marriage is a matter intimately related to her lifelong happiness. Looked at from this point of view, a minor girl stands as much in need of this right as a grown-up woman. If maturity of judgment and great affection can entitle the father or grandfather to overrule the discretion of a minor girl, the discretion of a grown-up daughter can also be overruled on the same ground. 3. The maturity of judgment and depth of affection ascribed to the father and the grandfather are only an act of empiricism, not a universal law. There is no dearth of exceptions where there is little affection and still less maturity. 4. Even in cases where the father and grandfather are men of insight and have deep affection for the minor girl, it may well be that their expectations do not come true. The boy may grow up into a young man, contrary to their expectations. This is all the more likely in these days of galloping social changes sweeping across the globe. Age-old concepts and practices that had been sacrosanct for generations are being brushed aside as symbols of backwardness. In such circumstances, the course of prudence is to discourage child marriage as far as possible. An irrevocable tie is likely to become an acute problem in future for the father or the grandfather who arranged the marriage. 5. In case the father or grandfather giving the minor girl in marriage is evil living, immodest, and reckless, the girl on attaining adulthood, though she gets the right of exercising her discretion, will have to prove in the court the moral blemishes that disqualify the father or the grandfather. This will be too embarrassing a task for her to undertake. The above factors make it imperative that this ruling of the Sharia law should be revised. Public interest demands that it should be so amended that the minor spouses, the girl as well as the boy, get the right of exercising their discretion on attaining adulthood. 4. Conditions for the exercise of discretion. Another ruling of the jurists on this issue also demands a critical look. In case minor girl is given away in marriage by someone other than the father or the grandfather, she has the option to exercise discretion on attaining adulthood. But the condition is that she should declare her disapproval immediately on the beginning of the first sign of puberty. If she does not declare disapproval on the first discharge of the menstrual course, she shall lose the right of discretion. The amazing thing is that this condition applies only to a virgin. The ruling for a girl touched by a man and for a minor boy is that as long as they do not declare their consent, they shall have the discretion to dissolve the marriage tie. The condition laid down for the minor virgin finds no support from the Quran or the Hadith. This is a judicial ruling and needs amendment. The discretion to dissolve the marriage has been conditioned by the beginning of puberty only because puberty brings in its wake maturity and the ability to distinguish between good and bad. Mature judgment enables one to act with responsibility. This does not imply, however, that the first sign of puberty brings about an instant mental revolution, making the individual capable of independent judgment. Even if such a sudden change does come about, why is the minor virgin placed on a footing different from that of the minor boy and a minor girl touched by a man? The latter two have been granted the discretion, after attaining adulthood, to dissolve marriage as long as they have not expressed their consent to it. On what grounds, after all, has the minor virgin been denied sufficient time to make up her mind after careful thought? An inexperienced virgin certainly needs more time to think and weigh things than does a young man and a young girl of her age who has been touched by a man. The minor virgin is much more inexperienced and immature than these two. 5. Dower. As for the amount of dower, no limit has been set on it by any mandate of Allah and His Messenger. Hazrat Omar once planned to set a limit. Learning of this, a woman came to him and cited the Quranic verse, "Even if you have given one of the women a huge amount of dower, do not take back anything." Hearing this, Hazrat Omar exclaimed, "The woman was correct and the man mistaken." No legal limit can be imposed on dower. However, the verdict of the above saying is that it is undesirable to fix a dower which is beyond the means of the husband. The advice given in this matter by the Holy Prophet was, try to enable men to pull on with women, do not get beyond limits in fixing the dower. Abu Amr al-Aslami married a woman for a dower of 200 pieces of silver. The Holy Prophet remarked, "Even if you were to find silver pieces washed down by brooks and streams, you would not have fixed a dower higher than this." Anas married a woman for 160 silver pieces. The Messenger of Allah remarked, "It seems you are digging silver out of this mountain." Hazrat Omar summed up his views on the issue thus, "Do not exceed the limits in fixing dower. Had this been something conferring merit in this world or in the hereafter, the Messenger of Allah must have outdone all of you. But the dower of none of his wives and daughters exceeded 480 silver pieces." These comments shed light on the undesirability of fixing excessively high dower, but the current practice in our country is far more deplorable. Deeds specifying hundreds of thousands of rupees as deferred dower are drawn up, but neither is the payment of these sums within the means of those making the commitment, nor does the intention of payment ever cross their minds. This sorry state of affairs is not only disgusting, but also corrupting. The ruling of the Holy Prophet in this matter is, a man who marries a woman in return for an amount of money, but has the intention of never paying it, is in reality an adulterer. One who borrows money with the intention not to pay it back is in reality a thief. This is the spiritual demerit of high dower. The material demerit is in no way less serious. The purpose of a huge amount of dower is to debar the husband from divorcing the woman. But on the contrary, in case the spouses cannot pull on together, the unusually heavy rate of dower becomes a millstone round the woman's neck. Inability to pay a huge amount deters the man to divorce her, and she remains suspended for years, maybe for the whole of her life. Excessive dower is one of the factors which is causing hardship to our women. If the dower is kept within reasonable limits, a large number of the marital problems will not get bad to worse. The existing situation can be solved without contravening the Sharia laws. If the dower is made immediately payable, the parties may be at liberty to fix any amount they please. In case the dower is deferred, the deed for its payment should be drawn up on a regular stamp paper, bearing stamps for at least 50% of the amount of the dower. A marriage deed which does not fulfill these requirements should not be legally admissible. Such a law, if enforced, will easily put an end to the rotten type of deferred dower prevalent nowadays. This law will force people to fix dower according to their means. It will also compel them to stop wasting money on stupid customs and pay the dower at the time of marriage, either in cash or in the form of property. When healthy traditions have struck firm roots, the legal requirement can be done away with. 6. Living expenses. Disputes arising on this count can be of two kinds. I, the husband, can afford to pay living expenses but does not pay. I, he simply cannot afford to pay. For defaulter of the first type, agreement that the court should take all possible measures to force him to pay. There is a difference of opinion as to what should be done if the man fails to comply with the orders of the court. The Hanafi view is that nothing can be done in the matter. It is for the woman to think of the ways of meeting her living expenses. She may borrow on the security of her husband. She may take up work and earn a living, or she may get help from her relatives. The Maliki view is that in such a case, the court has the right to separate the spouses by pronouncing a divorce. Some of the Hanafi jurists have approved of the Maliki ruling, with the proviso that the woman be incapable of fending for herself, or even if she is capable, there lies the danger of her overstepping the limits of Allah. But evidently this proviso seems to be out of place. The Quran has granted the wife living expenses as a matter of right. It is in return for this right of hers that the husband gets the conjugal rights on her. When the husband is deliberately denying her this basic legal right, there is no reason why she should be forced to stay bound by the marriage tie. If someone gets a commodity and gives nothing in return, or receives goods and refuses to pay the price, how can he claim possession of that commodity or those goods? As long as a woman is bound in the marriage tie, her husband is responsible for her maintenance. What rule of justice can require her to earn her own living, or to become a burden on her relatives, or to borrow in the name of a cruel husband? In the second case, too, the Hanafi ruling is that the woman should be advised to put up with the situation with patience and self restraint, and to borrow or seek help from the relatives. The ruling of Imam Azam is that her living expenses have to be borne by the person who must have been responsible for her maintenance in case she had stayed unmarried. However, the ruling of Imam Malik, Imam Shafi'i, and Imam Ahmad bin Hanbal is that if the woman cannot pull on with the husband and asks the court for separation, she ought to be separated. Imam Malik recommends 1 or 2 months' notice to the husband. Imam Shafi'i thinks that a notice of 3 days is enough, whereas Imam Ahmad favors immediate separation. The Quranic verse granting the husband conjugal rights in return for the money he spends supports the position taken by the last 3 Imams. The hadith and other evidence are also on their side. Qutni and Baihaqi quote the decision of the Holy Prophet, peace be on him, that in case of non-payment of living expenses, the spouses should be separated. The same ruling was given by Hazrat Ali, Hazrat Omar, and Hazrat Abu Huraira. Among the later day authorities, Sa'id bin Musaib and Omar bin Abdul Aziz also acted on this precedent. On the other hand, the Hanafi argument is based on the Quranic verse, "He whose provision is limited, let him spend of that which Allah has given him. Allah asks not of any soul except that which He has given it." 65:7. The implication of this verse is that no specified amount can be fixed for living expenses. The amount depends on the means of the husband, but it does not mean that in case the husband is absolutely without means, the wife should be forced to suffer miserable life with him. It would indeed be a heroic deed if she could do it, and Islam expects its daughters to develop such rare quality. Women of good breeding do rise to such moral heights. All the same, morality is one thing and a legal right is another thing. Maintenance is the legal right of the wife. If she willingly forgoes it and enjoys her husband's company even without it, it is highly laudable. But if she does not want to forsake it, or is unable to do so, there is no provision in the Islamic law that can force her to be content with her miserable lot as an act of heroism. The foregoing discussion points to the conclusion that the best solution to the problem is the one suggested by Imam Malik, Vizandandi, separation between the spouses after a reasonable notice to the husband. 7. Undue oppression. As for those from whom you fear rebellion, admonish them and leave them alone in their beds and give them a beating. Then if they obey you, seek not a way against them. 4:34. This verse does not give the husband the right to be harsh on the wife, either verbally or physically, without a genuine cause. In case he does this, the woman is entitled to legal protection. No precedent, however, can be cited to explain the details of procedure in such a case. But the Islamic law is humane enough to permit the court to provide relief to the aggrieved woman in unbearable cases by separation between the spouses. In some sections of our society, ill treatment of the wife seems to have become a common practice. Being a husband is looked upon as a license to inflict unbridled injury and injustice. There seems to be a need to include in the Islamic law suitable clauses to check this cruel practice. The best that can be done is to include the habitual use of filthy language and the frequent resort to beating among the legitimate grounds for demanding kula. Women who can prove such treatment on the part of the husbands should be granted separation without making any payment. 8. Arbitration. Appoint an arbiter from among his people and an arbiter from among her people. Where differences between the spouses become a threat to the marriage tie, the above verse of the Quran provides the right solution. That is what Hazrat Ali did. A case is reported in Kashf-ul-Gumma. A man and his wife, who were on very bad terms, came to Hazrat Ali. He told each of them to choose an arbiter. This done, he summoned the 2 arbiters and said, "If you feel that union between the 2 of them is the right thing, keep them united. But if you feel their separation is the right thing, separate them." Then turning to the woman, Hazrat Ali said, Will you accept the verdict of the arbiters? Her reply was, Yes, I will. When the same question was put to the man, he replied, If they retain the union, I will accept the verdict. If they separate, I will not accept. At this, Hazrat Ali gave his verdict. You do not have such a right. You shall not leave unless you promise to accept the verdict of the arbiters, as the woman has promised. Such arbitration is a suitable device for settling family disputes which do not involve complicated legal issues. To make arbitration still more serviceable, it is necessary to add a few more clauses to the law. The clauses should clarify the procedure of arbitration, the powers of the arbiters, the mode of the enforcement of their agreed decision, and the course of action if the arbiters disagree. The attempt of the Islamic law to settle most of the family squabbles at home instead of dragging them into the court is a very precious feature of this law. Even when a case reaches a court, the judge is required, before making a probable himself, to get help from the responsible members of the two parties for solving this problem. This too is a blessing for social life. 9. Option of dissolution for serious disability. Great differences exist between jurists on the question of the dissolution of the marriage when one of the spouses discovers after marriage that the other spouse is suffering from a serious disease or loathsome physical defect. A section of jurists is of the view that neither of the spouses has the option of dissolving the marriage on the ground of a handicap or a shortcoming of the other spouse. The ruling given in the Dur-e-Mukhtar is, neither the husband nor the wife has the right to get the marriage dissolved on account of the handicap of the other, however serious the handicap may be, like madness, leprosy, leukoderma, hernia, etc. This view has been held by Hazrat Ali and Ibn Masud from among the companions, and by Ata Nakai, Omar bin Abdul Aziz, Ibn Abi Layla, Awza'i, Thawri, Abu Hanifa, and Abu Yusuf. The other section of jurists holds the view that handicaps which are a barrier to conjugal relations give both spouses the right of dissolving the marriage. The handicaps listed are madness, leprosy, leukoderma, foul-smelling mouth, venereal diseases. Imam Malik is the propounder of this view. In his book Al-Qawanin, Abu Ejaz lists these handicaps and states that if either one of the spouses has any of these handicaps, the other spouse has the option to live together or to separate. According to Imam Shafi'i, both spouses have the right of dissolving marriage in case one of them is suffering from madness, leprosy, or leukoderma. But venereal disease, foul-smelling mouth, and itch are no grounds for the option of dissolution. But if the woman has a sexual disease that rules out intercourse, or the man is impotent, or he is a eunuch, the deprived spouse has the option of dissolution. According to Imam Muhammad, no handicap of the woman gives the husband the option of dissolution, but his madness, leprosy, and leukoderma give option to the woman. Of all these views, the second one is closest to the teachings of the Quran. In the eyes of the Quran, the two most important objectives of the marital relationship are the preservation of chastity and the bond of love and compassion between the spouses. These objectives get lost if either one of the spouses is afflicted with a disease or a handicap which disgusts the other or renders him or her incapable of satisfying the natural urge of the other. Another principle of Islamic marital law is that the marriage tie should not be a source of causing harm to the spouses or a cause of forcing them to transgress Allah's limits. If there is no option for dissolution on the ground of the above-mentioned afflictions, this principle is certain to be violated. The aforesaid disease and handicaps certainly cause harm to the normal spouse. And there is also the ever-present danger that hatred or the lack of sexual drive may prompt the normal spouse to violate Allah's limits. Thus, it appears necessary that these afflictions should give the spouses the option to dissolve the marriage. The discussion has thus far been restricted to cases where the spouses did not fully know each other's personal conditions before marriage, and they expressed their disgust as soon as the true picture of the other spouse became known. But there can also be cases where the spouses fully knew each other before marriage, and they knowingly entered into the marriage tie. It could also be that they were not aware of the defects before marriage, but when they came to know of it, they did not use the option to dissolve marriage. Another possibility is that of the disease or the handicap developed after the marriage. In all these cases, the man has an alternative: he can divorce. Another alternative for him is to have second wife, but in certain cases, the jurists have suggested no remedy for the woman. Some jurists have in some cases devised a way out for the woman, but others have not approved of it. The rulings given on this issue will be taken up and discussed one by one. 10. Impotency. All agree that if the husband's private part has been amputated, the woman has the right to ask the court to separate her, and if the fact is established, separation shall be made forthwith. If the husband is impotent and the woman demands separation, the husband, according to the precedent set by Hazrat Omar, will be given a year's time for medical treatment. If he is still impotent, separation will be made. However, jurists have laid following conditions. I. This ruling is applicable only in cases where the woman was unaware of the man's impotency at the time of marriage. If she was aware and still willingly married the man, she cannot demand separation. I. In case she was unaware beforehand and discovered the fact afterwards, but still declared her consent to retain the marriage tie, she loses her right to demand separation. I. Separation will be effected only if the man has not had a sexual intercourse even once. If there has been even a single intercourse, and that too an unsatisfactory one, the woman loses the right of separation. These conditions find no support from the Quran or the Hadith, and they are unjustified. If a woman is foolish enough to marry a man whom she knows to be impotent, it is both unfair and unreasonable that she should be irrevocably condemned to share life with him. The evils stemming from such a union are too evident to be discussed. It will be enough punishment for her if she is separated and deprived of the dower. If a woman comes to know of her husband's impotency after marriage, and she initially consents to live with him, she has committed no serious crime for which she should be forced to spend the rest of her life in misery. An inexperienced virgin at the threshold of married life can hardly imagine what hardships await her in her union with an impotent husband. Maybe because of her good nature, she takes a light view of the matter and thinks she will be able to carry on anyway. But if later she comes across hardships too formidable to bear, and perplexed with the fear of ill health or slipping into sin, she demands separation, how is it permissible to snub her and tell her either to pine away the rest of her days or to compromise with sin? The more you think, the more strongly you feel that hurling a woman into such a situation is diametrically opposed to the teachings of the Quran. The situation can explode into a more harmful scenario that will not be restricted to the individual person of the woman, but will also infect the whole society, and the infection will be transmitted to coming generations. Rather than running such a grave risk, it is far better to take a humane view of the mistake made by a woman. Separation will do her no harm. If at all she is to be punished, let her lose the whole or part of the dower. As a matter of fact, even this punishment will be unfair. More deserving of punishment is the man who married a woman despite his impotency. The third condition is also very harsh. This type of conjugal relationship does not measure up to the Islamic objective of marriage. Islamic law has not been designed for heavenly beings, but for the humanity. It is extremely difficult, if not impossible, for an average woman to have only one or two or few intercourses throughout life and feel happy and satisfied, keeping her chastity intact. Even if it is assumed that 50% of the women can rise up to this standard, what will happen to the remaining percent who do not come up to a very high level of patience, self-restraint, morality, and chastity? Will the responsibility of their licentious living not rest on the law that closed for them the lawful way, pushing them into a life of sin and corruption? The inevitable conclusion from these stark facts seems to be that in every case of impotency, whether it existed before marriage or developed later, the woman should have the right to go to the court. If after a reasonably long medical treatment, the maximum limit for which should be a year, the defect persists, separation must be made. The view of the jurists is that if, after the year-long treatment, the man is able to have intercourse, even partially, the woman loses the right to separation for good. This view again is unduly harsh. The correct course of action will be to rely on medical opinion. If the expert opinion is that medical treatment has failed to restore his potency enough to fully discharge his conjugal rights, separation must be made. The jurists have placed the castrated and the impotent in the same category and have allowed the former a year for medical treatment. The reason given is that there is hope of his developing ability for intercourse, but it has been proved by medical research that there is no difference between the castrated and the man whose private parts have been amputated. A man's private parts may have been cut off or his testicles may have been destroyed. In both cases, he is equally unfit for sexual intercourse. No medical treatment can restore potency to such handicapped males. The castrated belongs to the category of the amputated private parts, not the impotent. 11. Madness. The ruling given by Hazrat Omar is that a year's time should be allowed for the medical treatment of the madman. If treatment fails to cure him in a year, the wife should be separated. The ruling has been accepted by jurists with the addition of sub-clauses. Imam Abu Hanifa's view is that this ruling applies to the man who was mad before marriage and was unable to have an intercourse after marriage. In this respect, he is as good as impotent. That is why he gets a year for medical treatment. According to Imam Muhammad, if madness is fitful, a year's medical treatment will be allowed. But if it is perennial, the fellow is as good as the man without private parts requiring immediate separation. Imam Malik is of the view that the medical treatment of madness, whether fitful or perennial, should get a year. If there is no cure at the year's end, separation should be made. Maliki jurists have added conditions. 1. If the man was mad before marriage and the woman knowingly married him, she cannot demand separation. 2. If she gets to know of his madness after marriage and declares her consent to live with him, she cannot demand separation. 3. In case madness affected the man after marriage, the woman can demand separation only if she did not declare her consent to live with him, nor allowed him of her own free will to have intercourse with her. These conditions are of the same nature as the conditions discussed in impotency. They find no support from the Quran and Sunnah and are open to serious objections. If a woman is kept forcibly tied to a madman, the objectives of the Sharia, the civilization and morality, can never be realized. If she knowingly married him, relinquishing the dower is enough punishment for her. If she came to know of his madness after marriage and consented to live with him, but later the resultant physical and mental agony became unbearable, she committed no crime for which she should be condemned to lifelong union with a madman, exposed to sorrow, misery, and great hazards. In case the man was afflicted with madness after marriage and the wife, out of loyalty and noble feelings of fellowship, did not abruptly leave him, but chose to look after him and share life with him, this should not be made a ground for denying freedom to her when the madness of the man becomes unbearable for her. Such a ruling can only put an end to all humane feelings between the spouses. The intention of the law will seem to be that the moment a woman notices symptoms of madness in her husband, she should forthwith forget all previous love and compassion and curtly leave the husband to his fate, knowing full well that if the madness assumes an intolerably perennial form, the feelings of loyalty and fellowship now welling up in her heart will ultimately spell disaster to her, putting her to untold agony. The imposition of such conditions projects an exaggerated image of the man and metes out a harsh treatment to the woman. If a woman becomes good for nothing, becomes mad, or contracts a loathsome or dangerous disease, the man can divorce her, or he can marry a second wife and lead a happy life. But if the husband becomes afflicted with any of these handicaps, the woman can neither divorce him nor marry another man during his lifetime. Separation is the only remedy for her. When this sole remedy is hedged round with restraints which in most cases leave no way out for her, it offends the justice and balance that are characteristics of the Islamic law. In all such cases, the guiding light for us should be the Quranic verses, which assert that marriage should be a relationship of kindness. The bond of marriage should be free from insulting behavior and excesses which threaten the violation of the limits of Allah. A marriage bond that is devoid of these characteristics should end in decent separation. Who can say that anything can cause a greater harm and injustice to a woman than to forcibly keeping tied down against her will to a man afflicted with madness, venereal disease, or leprosy? Is there anyone who does not realize what evil temptations surround a woman forcibly pushed into such desperation, and how hard it is for an average woman to spurn these temptations? 12. The missing husband. There is no definite mandate in the Holy Quran regarding a missing husband about whom nothing is known. Qutni has reported a hadith. The Messenger of Allah said, The wife of the man who is missing and about whom nothing is known remains the wife of that man till facts about him have come to light. The hadith has been reported by Siwar bin Musab and Muhammad bin Shurja'il Hamdani, both of whom are not very reliable. Ibn Abi Hatim's comment about Shurja'il is, he reports from Mughira things that are unreliable and false. Ibn al-Quttan's remarks about Siwar are, he is even more unreliable than Ibn Shurja'il. Thus, this hadith is not to be relied upon. Moreover, the divergent views held on this issue by notable luminaries like Hazrat Omar, Hazrat Usman, Hazrat Ali, Ibn Abbas, Abdullah bin Masud, and Abdullah bin Omar are further evidence that neither they nor any other companions had any knowledge of the above quoted hadith. Had any of the companions known the ruling of the Holy Prophet, peace be on him, on this issue, he must have come forward to clarify the difference of opinion. Shurjail has reported this hadith from Mughira bin Shuba, who was a well-known figure in the days of Hazrat Omar and Hazrat Usman, and occupied the high office of a governor. If Mughira had known this hadith, how would he have allowed Hazrat Omar and Hazrat Usman to decide cases contrary to this hadith? This solves the point that there is no mandatory law on this issue. Scholars have to be guided by their best judgment to decide the case about a missing husband. Differences exist on this issue in the opinions of the companions, their successors, and the leading jurists. In the opinion of Hazrat Omar, Hazrat Usman, Ibn Omar, and Ibn Abbas, the wife of the missing husband must wait for 4 years. The same view has found favor with Sayyid ibn Musayyab, Zuhri, Nakhai, Ata, Makhul, and Shabi. Imam Malik also adopted the same view. Imam Ahmad also leans towards this view. On the other hand, Hazrat Ali and Ibn Masud are of the view that the wife of the missing husband must wait until he is found, or his death is confirmed. This view has been adopted by Sufyan Sori, Imam Abu Hanifa, and Imam Shafi'i. Concerning the period of waiting, Hanafi jurists suggest that the wife of the missing man should wait till the other men of his age living in the community are alive. Some have fixed the period of waiting, making the maximum age expectancy as their yardstick. For example, if a man was missing when he was 30, his wife should wait, according to some, for 90 years, according to others, 70 years, according to still others, 60, and according to some others, 50 years, and according to the most considerate, 40 years. The difference in the length of period is the result of the difference in the life expectancy of man assumed by different jurists. So if the woman was 20 when the man disappeared, according to the most lenient view, she will have to wait till she is 60. She will then be free to marry a man of her choice. After taking a look at the matter in the light of the Quranic principles, we feel that the view adopted by Hazrat Omar and his followers sounds correct. It is in keeping with the spirit and the nature of the Islamic law, as well as with its concern for justice and balance. Take, for example, the permission to marry 4 wives. It is also accompanied by the warning, do not totally lean to one of them, leaving the rest suspended. The warning highlights the Quran's abhorrence of leaving a woman suspended. When such is the case in the existence of the husband, how can the Quran approve of keeping a woman suspended indefinitely when the husband is missing? Discussing the case of women left alone in their beds as punishment, the Quran puts the maximum limit at 4 months. Beyond this limit, divorce becomes a necessity. This mandate underlines the fact that Islamic law does not approve of depriving a woman of sex to the extent that causes her harm or drives her to transgress Allah's limits. Another Quranic mandate warns, do not retain them to cause them harm. The clear implication is that marriage should not become a source of affront and injury. If the wife of the missing husband has to wait for the rest of her life, the harms inflicted on her can well be imagined. In this background, take a look at the mandate. If there is a danger that Allah's limits will be transgressed, there is no harm if they separate. This amounts to observing Allah's limits above the retention of the marriage tie. Who can deny that a woman whose husband has been missing will find it increasingly hard to stay within the limits of Allah? Having a sharp glance at these mandates and their implications for the social good, one can easily understand that it is wrong to keep the wife of a missing husband in suspense for an indefinite period. 13. Maliki rulings about the missing husband. The foregoing discussion explains why Hanafi jurists have preferred to follow Maliki rulings in their verdicts on cases of missing husbands. Let us take a look at the details of Maliki ruling. Malilki jurists have divided these cases into three categories with different rulings for each. I. In case the missing husband has not left behind enough property for the wife to live on, the court will not tell her to wait, but after a probe, the court will forthwith use its powers to grant her divorce, or it will tell her to make divorce self-imposed. This Maliki ruling is followed by Shafi'i and Hanafi jurists as well. The reason being that, according to them, the absence of living expenses is in itself a sufficient ground for separation. Tien. If the husband has left behind property on which the woman can live, the court will look into the material details of the case, and if the woman is youthful and keeping her suspended for long can expose her to sin, the court will tell her to wait for some months or for a year as it may deem fit. This stand is endorsed by the Hanbali jurists as well. In extreme cases, the jurists of both Maliki and Hanbali schools consider immediate separation also permissible. They also agree that to determine the exposure to sin, it is not necessary that the woman should declare bluntly that the retention of the marriage tie was sure to drive her into sin. It is for the court to take a probing look into the circumstances of the woman, her age, her upbringing, her social environment, and the period she has already spent in waiting, and other allied factors should guide the court to form its opinion as to how long she can wait without any danger to her morals. 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 Any danger to her morals.